Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Oh, for crumb's sake. I didn't ask you to interrupt me. Dahil mihi Anglican po, he's very club.
Is that correct?
Good morning. Helps by unmute my microphone. Welcome to the Court of Public Opinion. Happy Friday to you. I am the Recovery Addict. And it's really early. I think this is the earliest we've been live in a long time. Somebody gave us a 12-month membership message and then retracted their message, and now it's gone. And I don't know who it was. No. But I know who was first in chat. Ali G, UK. Congratulations. You're first in chat. Because of that, we're going to punish you for your promptness and your punctuality. Yes, everything IP related on this Friday the 13th is your responsibility, so you know it's going to be a bad one. Unlucky for lots of people, possibly the au pair specifically. But welcome. We have good morning from Monmouth County. Hey, Laura. Welcome. Are you going to be in court? Curious. Just going to see what the verdict is. We do have a timer running, which I started arbitrarily about 6 minutes ago. Judge said if you're all here at 8:02, you can start deliberating. So I just assumed that that's what the jury decided to do. So I'll show up at 8:02 and start deliberating. We won't know exactly when they start deliberating. It could be as late as 8:30. Or, if a juror has a problem, a little later. So, yeah. All right, welcome. I do apologize for the podcast last night. As always, hope you could watch it and then forget about it. That was an interesting one. Let's see. I messed with your internal clock. I'm so sorry. I am still tired. I don't know why. Well, probably because I went to bed late. But other than that, I don't know why. But I'm a little sleepy, bleary-eyed. Had a quick breakfast and came and joined you. Let's see. Momo Chappers, yay, it's my birthday, sitting in comfy clothes and doing nothing. Well, Momo Chappers, if it's your birthday, we have to sing to you. Are you on the birthday form? Hopefully you filled out the birthday form. And the judge can wish you a happy birthday as well. If it works, why is it not working? Why is there no sounds? Why is the rum gone? Let's see. What do we have here? Reconnecting. It's there. It's connected. It should work. I'm not in court. Just watching your channel. Newbie here. Welcome. Newbies are always welcome, Laura. And don't apologize for not being in court.
With more experience.
Most of us wish we'd be in court, and we just can't be every day. My friend's sister works in that courthouse and said the person that got kicked out wasn't media, but random viewer using their phone. And it was the third time, too. Murder Show 66. Congratulations. Member milestone 27 months on the jury. That makes you an OG. Thank you very much. Thank you. We're excited to have you here. Congratulations on the 27 months. We're going to sing happy birthday to kick everything off this morning. Greeners came in just before Josh on this one. But let's see, the lists are a little different. Let me double check. Nope, they're the same. It's just Josh's name is longer. That's all. Okay, they're all good. And Josh has 2 emojis where Greeners only used 1. So I see what happened there. All right, we are going to sing happy birthday using Greeners. Sorry, Josh. He beat you to it. we're going to sing happy birthday to these wonderful people. And by we, I mean all of us. So wherever you are, whatever you're doing, and whoever's around you, it doesn't matter. Stand up wherever you are, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We got it. We found it. It was a little bit of a warble, but then we nailed it. Here we go.
Birthday. You look good.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Ansley, Bernie, Cat Pool, Mandy Wright, and Mama Chappers. Happy birthday to you. I just realized we have a lot of birthdays today. We got these ones already, and now we're going to sing to these ones right here. So Sarah, Thea K, and Tracy Gingrich. Happy birthday to you. Happy birthday to you. Happy birthday, dear Sarah, Thea K, and Tracy Gingrich. Happy birthday to you. Is it Gingrich? I don't know. Tracy, hopefully I said it right one of the ways. But Ansley, Bernie, Cat Pool, Mandy Wright, Moma Chappers, Sarah, Thea K, and Tracy Gingrich, happy birthday. There are many wonderful days, but today is your special day. And I realized you could have been a million different places and celebrated with a million different people, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully you can make that joy, return that joy back to you, make your day a little bit specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, and Bob Evans. Let's see. Happy birthday to Alita's 27th wedding anniversary. Greeters, what? Happy birthday to you. I'm not sure what I'm singing here, Greeters. Happy birthday to you. Happy birthday, Alita's wedding anniversary. Annika, Colleen K, Daniel, Emma, Jora, and Patty, happy birthday to you. Where did these ones come from? Greeters, where did these come from? Happy birthday to Alita's 27th wedding anniversary. Annika, Tisha's daughter. Colleen K, Daniel, Emma, that's Reland's granddaughter. Georgia, and Patty, who's 70. Wow, that's a lot. Okay, that's good. Happy birthday, everybody. Drum solo for the big finish. Ready? Greeters. Those are tomorrow's birthdays per red pen. All right, I just didn't know they were coming. That surprised me. Thank you very much. The weekend has a lot of birthdays as well. I thought it was in the clear and had nailed it, and I was only halfway done. Murder Show 66 gifted 5 memberships to kick things off. How's that for a birthday present? Happy birthday to those who received this gift, even though it wasn't your birthday necessarily. The second list is tomorrow's. Thank you. You guys were on the ball. I just was not following. I realized I said it was Friday, but mentally I haven't gotten there yet. I haven't got we're at the end of the work week, which is all good. So. Let's do a couple things, shall we? Let's get a timer going. Let's do 3 is going to be 4 right now. There we go. That way we can have a timer going. This is what we anticipate or what we think may be possibly a semi-accurate counter as to where the jury is on their deliberation, time-wise. And let me tell you what I think is going to happen today, because it's my show and I get to do that. 3 hours minimum. It's going to take 3 hours. It's going to take 3 hours for them to figure out the 16 forms and the convoluted, if you feel this, then you have to figure the value of that. This is not a fill-in-the-blank assignment. They were given a closed book, closed note, trigonometry test without any training. I think it's going to take them some time, even if they're all, even right now, decided. I think 3 hours. That's my call. So I put it out there first. A lot of you guys say, you never tell us what you think. There, now you know. That's what I think. And let's see, what box is that? That's camera 1. That's camera 2. Okay. We need to get rid of the microseconds is what I'm going to do here. Let's just slide this over and pretend they never even happened. There we go. All right. Thank you to our amazing mods for doing the birthdays this morning. Personally, I'm opposed to doing birthdays in advance. You have to earn that extra day of life before we sing to you. Let's see. Mods are amazing. What is the case? A recap. Chris Plamadon. The case we're talking about is the Paul Caneiro murder trial. Paul is a brother to Keith Caneiro. Keith is not with us because he has six. He was shot 6 times in his yard. It was as he was going out to check out why the power was out at his house, why the electricity had shut off, why the generator had not kicked in. As he's headed out to that, he gets shot 6 times. His wife was then shot and stabbed and killed by being shot and stabbed, as were his 2 children, 11 and 8-year-olds, stabbed and possibly shot, one of them. Then his house was lit on fire, and the fire smoldered for hours until the fire department showed up, opened the door, and then the oxygen came in, fire lit in a big way. But 4 people are dead, and investigation. Initially, the first connection they had was, wow, we've got a fire. That's 2 fires today. We had one over at the Caneiro home over in one side of the town, and then we had this one at the Caneiro home at the other side. And they said, did you say the first one was Caneiro too? Yeah. Paul's house was on fire that morning as well. So the police obviously say, what are the odds that 2 people with the same name have fires the same night? And one of them is clearly a murder and then an arson. What are the odds of that? And then even yet better, what are the odds that they're brothers? That's just...
Remember in the beginning when we started 110 years ago?
Yes, it was a long time ago that we started doing that. That was the judge during closing statements. But they started putting things together and started looking at things. They got evidence. They got 911 calls of people in the middle of the night saying, I just heard gunshots, and went bam, 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 bam. And then boom. And wow, 6 bullets outside killing Keith, nailed it as far as the accounting goes. The timeline started coming together. They started getting security camera footage from houses in the area, and they were able to put together a video of a very unique car, one that happens to match Paul Caneiro's car, driving from Paul Caneiro's house to Keith's house and back around the time frame of the same the shots and the fire. Paul says he was in bed all night. Hadn't been down in the basement since 4 p.m. the night before. Just was sleeping, as one does. The only problem is Paul's security cameras show that Paul unplugged his security cameras at 1:30 in the morning down in the basement and in the garage. And oops. Also, there's firearms tool marks evidence that points to Paul's guns, which he swapped the barrel on a gun, and he had the offending barrel, the one that matched the crime scene, in his backpack in his wife's car when he left his house with the fire, along with all the savings bonds, passports, important documents, driver's license, everything that belonged to the whole family. So he had that with him, but the rest of the gun, the receiver part, the other barrel that wasn't used, and the handle and everything, that was locked up in his safe, the one he said he'd never been down to. So we know that gun was used, and then it somehow went into his safe, locked up, before his house miraculously also caught fire. Oh, and there's one more thing. There's a pile of clothes which appear to have fit Paul, that have his niece and nephew's blood on them in his basement. That was mostly burned, but the firemen put it out too quick. So there's a little bit of facts. There's a little bit of facts that are not going to look good for him in the long run. I think for the jury, this is a no-brainer. This is not circumstantial evidence. We have some hard evidence in very difficult to explain places. But Paul says, oh, sure, yeah, you've got my DNA or what could be me, but you never tested my brother Corey. Because maybe Corey's a better match than me on the DNA. I'm not sure if he just doesn't know how DNA works, but when they say 1 in 48 quadrillion, I think that includes Corey as the quadrillion. It's not him. It's not him. But to their credit, the state never tested Corey, so they can't say for sure it wasn't him. They just know that all the evidence only pointed at Paul, and that's where they followed. So there is one more thing to talk about in this wrap up of the case, and that is that closing arguments were just terrible, like worst ever. The defense went first, and then the state, so they each get one turn. The defense took 3.5 hours, and most of that 3.5 hours was spent telling you what the state was going to tell you, all the hard evidence, the facts. It was like the state was giving like a quick peek behind the curtain of what you're about to hear. They're going to tell you he's guilty because of this, and they're going to tell you he's guilty because of this, and because of this, and because of this, and because of this. It was the worst closing, I think, in the history of ever, until the state got up and took 5 hours and 25 minutes to wander aimlessly about a warehouse full of evidence with a PowerPoint that was only marginally better than the defense's. And by marginally, I mean they used red as a font color instead of just the black and white and a gajillion words on every screen. And they did a better job implementing a few videos. So that was basically where we are. We are very happy to be done with the closings and looking forward to the jury doing their job. And they did not start deliberating last night, so we've got the timer going right now, showing that they possibly have been deliberating for as much as about 20 minutes. And that's a good start. Okay, I had a melanoma removed 4 months ago today. 4 months ago, going in today to keep an eye on it. If you're reading this, it's your reminder to get your skin checked. Jody, thank you very much for the reminder. Always good advice.
Remember in the beginning when we started 110 years ago?
Yeah, it was a long time ago. The red ink didn't fix it. It made it sort of a little bit worse. I told you yesterday my worst fear in this trial, my worst fear, is the jury's going to come back and convict Paul on all 16 charges. Guilty. And the prosecutor will think it's because of his closing. And he's going to do it again to some other poor jury. He's going to think that it was because of him. I think, if anything, it will be in spite of his closing. Because he literally introduced doubt better in the prosecutor's closing than the defense did in theirs. It was wild. It was wild. All right. So we are on verdict watch, which means we will keep an eye on court. Court looks like, well, I can show you what court looks like. It looks like this. Boing. That's live right now from the courtroom. We have a hot audio connection to court. So if anything happens, we're going to hear it as soon as it happens. And let me pin that, Josh. Thank you. And now the good news is it's Friday. And because we're here on Verdict Watch, we can sort of get to do, what we want. This is our free day, Friday free day. So we can talk about everything from food to family vacations, kids, you name it. The conversation can go just about anywhere. And we can also do a little bit of court hopping while also maintaining our little view of the corner of what's happening in court. So, let's see. We haven't got Bree's recap for emojis yet. We'll watch for that. She tells us the whole story in emojis. Red Pen, you might need to send me the link again. Josh, our great moderator who has his ear to the ground, the heartbeat of true crime across the nation, has started suggesting things to watch here. Josh, is it the whole video? It's a compulsory hearing. That means you have to listen to it. We do have the au pair sentencing happening today as well. She pled guilty and she turned state's witness, so she's got a plea deal. And we're going to see if the judge honors everything in that deal, because the judge can legally change it a little bit. Tracy, happy birthday. She's going to drop it in chat. Awesome. Will you cover Murdoch if he gets retrial? Knitting with me, is there any possible way is there any possible way that if we do go back to South Carolina for the Murdaugh Part 2, or Murdaugh Redo, as the case may be, can we separate the financial from the... I realize the financial is the motive, okay? I realize that was the world unraveling. Can we just keep the finances separate and just do the murder trial and just maybe stipulate to the fact? Can both sides just like, yeah, he had some money issues and he was stealing from everybody. Stipulated? All right, done. Okay, jury, here's the evidence of the murders. Can we do that? Because those 2 weeks of just, it was just, if you were there, it went like this. Like, what's on your screen right here? This is a check number, such and such, written out to something, and did that get deposited in their account like it was supposed to? No.
Alex stole it.
Okay, and how about this check? This is that's check number. Did that get deposited where it was supposed to? No. What happened to that?
And now Murdaugh stole it.
All right, and we have this check over here. This is for how much? Oh, okay, and who's it written out to? Okay, did that get deposited in the account where it was supposed to go to? No. What happened to that?
Alex stole it as well.
It was just nonstop. Alex stole it. Alex stole it. Alex stole it, and we got the picture on day one, but it went forever. So would we cover it? We would probably definitely cover the case. Would we watch the entire thing? I don't know. I'd like to see some of those characters again. Some of the lawyers had a lot of personality. That was spicy. I'd like to see more of some people we didn't get to see as much of. We got to see some people in proffer that didn't get to really testify much in front of the jury. So yeah, it could be really, really good that way. But Josh says, maybe watch video of what I sent you. It happened 22 hours ago, but article I sent you gives a background of what we were watching. Josh, is it the entire hearing? That's what I'm trying to ask. Is it the entire hearing? The lawyers were great. Poot was on LYK last night. Lawyer, That's awesome. Sorry, we're going to... Families yelling in the hallway in a happy way, like happy cheers and laughing. Yes, we're going to cover Juliana's sentencing today. No Judge Newman. Obviously, that's going to be different if we have another trial for Murdaugh. Let's see. Thank you, Red Pen. Josh, moderator Josh, paging Josh Hutchins. I've got the link you sent me. I just need to know, do we watch the entire thing? It's 31 minutes long. Is there a certain part? Am I supposed to read something beforehand? I know you said there's an article. Oh, now the article came through. I didn't see it before, so when I clicked on there was no article. Former Dallas County prosecutor accused of taking $20,000 PPP loan. What's a PPP loan? Private public partner? That type? For personal gain. What's $20K though? I mean, for elected official? That's small potatoes, right? $20,000 will get you elected as to your community as a commissioner in a small town. That's what $20,000. For anything else, it's one ad spend. All right. Oh, it's a COVID loan. Watch the whole thing. It's COVID safety. So personal protective. What's the third P? I'm trying to find out what the third P is. $20,000 PPP loan. Okay. All right. So that's the premise. Let's see if we can get this accessed really quickly. Give me a second to pull it up. It's a 31-minute, 55-second one. Okay, this is from yesterday.
Starting with the commission.
Ramiro Canales for the Texas Commission on Lawyer Discipline.
Respondent?
Texas
Thelma
Commission.
Anderson.
Mr. Canales, do you wish to make a brief opening statement?
Hang on.
Yes, I do, Madam Vice Chair. May it please the board. This is a compulsory discipline case based on respondent's conviction, and I stress voluntary admission, which resulted in a conviction of count 1 of the indictment filed on May 21st, 2024 for wire fraud under Section 18 U.S.C. Section 1343 in the United States District Court for the Northern District of Texas, Dallas Division. The petition for compulsory discipline was originally filed on June 3rd, 2025.
She's wearing a shut up and prosecute
to serve
shirt.
Ms. Anderson, and we were not able to, and a private processor provided an affidavit of non-service. We filed a first amended petition on August the 15th, and once again, we were not able to personally serve Ms. Anderson, and a constable who was asked to serve Ms. Anderson submitted an affidavit of non-service. On September the 9th, we filed, or that was
Where's Miss Anderson?
September the 9th was when the second amended petition was filed via certified mail. And Ms. Anderson signed the green card on September the 29th, and we received it here in the commission on October the 3rd of on October the 2nd, 2025. Because the card did not reach my litigation file until after October the 9th, on October the 9th, we filed a motion to pass, or we filed a letter passing the hearing that was scheduled in October. After we passed the hearing, I discovered that she had filed, or that she had signed the green card, and we filed a proof of service with the board after we had filed the third amended petition on December the 4th. And that is the petition that is currently pending before the board. I do want to say, provide a very brief background. As I mentioned earlier, Ms. Anderson was indicted on 3 counts. 1 was wire fraud. The other 2 were engaging in monetary transactions and property derived from unlawful activities. Eventually, Ms. Anderson voluntarily pled guilty to count 1 of wire fraud. In addition to voluntarily pleading guilty, she signed a factual resume with the court which specified the 4 elements of the wire fraud charge.
Mr. Canales, real quick, can we for right now, we're just going to take up the jurisdictional portion of the proceedings. So any other statements that you want the board to be aware of relating to the jurisdiction issues raised by Ms. Anderson would be very helpful. Thank you.
Well, Ms. Anderson has acknowledged service, submitted to the board her green card that she signed on September the 29th. That gives the board jurisdiction. She has noticed, and she's been given the opportunity to be heard, and she is here. So she has been served. She has been served with the petition. She is aware of the issues, and this board has jurisdiction to adjudicate this compulsory disciplinary matter.
Thank you. Ms. Anderson, again, if you'd like to make a brief opening statement regarding the jurisdictional issues, we can consider that.
Here goes. Buckle up.
The jurisdictional issue is not proper, as counsel stated. He stated it was proper. It's not proper. And I will go back to the original notice that I received via email on September the 4th of 2025, where I sent counsel an email asking for proof of service. That was the first time I asked for proof of service. September 6th of 2025, I asked for proof of service and the original petition. September 8th, 2025, I asked for proof of service and the original petition. September 19th, I asked for proof of service and the original petition. September 25th, December 4th, December 5th, December 11th, December 12th, December 15th, December 16th, January 31st, and January 31st of 2026 and February 6th of 2026. The reason I asked counsel for proof of service and the original petition was because I was afforded that right to have the original petition and proof of service, so that proper service would render personal jurisdiction, and it will attach. Every email that I sent counsel, he intentionally disregarded my request to have that information provided to me. And I stated to counsel in every email, and it's in documents that I have filed, and the emails that are a part of the exhibits, just give me proof of service. If you do not have proof of service or the original petition, you need to start this process over so that I can properly be served. Counsel never in that time frame turned that information over to me until December 16th, 2025, when he snuck in.
Ms. Anderson, we're getting beyond an opening statement. So
this is going towards the personal jurisdiction. You're asking me about personal jurisdiction. This is related to personal jurisdiction.
Okay. This is beyond the opening statement. So at this time, I'm going to have Mr. Canales, if you want to call any witnesses or offer any exhibits at this time, you may proceed with your case in chief for the jurisdictional issue.
I would like to introduce one of the exhibits that was submitted, and if I can do that at this time.
Which exhibit would that be?
It's the one dealing with Exhibit 8. Let's see. Exhibit 8, which is the affidavit of non-service from Caleb Michael Hale. Exhibit 9, the affidavit of non-service from the Deputy Counsel, and also Exhibit 7, which is the amended business records affidavit, which includes the proof of service that was filed with BODA.
Okay.
Exhibits 7, 8, and 9.
Ms. Anderson, do you have any legal objections to Exhibits 7, 8, and 9?
The legal objection that I have to the affidavits, I believe, would be 8 and 9. That is in reference to I'm assuming the constable. The legal objection is the documents are not valid.
That is not illegal.
Option and completeness. Because the documents are not from the date and time. They are from after 2026. So I need it's not option and completeness, because these documents, the metadata shows that it's from February the 10th that they were created, not August 28th, what it purports to be.
That objection is overruled. If you have no other objections, I will go ahead and admit those 7, 8, and 9.
Oh, well, my next objection is hearsay.
And
for the purpose
Commission,
of this,
are those business records affidavits in conformity with the rules?
Yes, ma'am.
Okay.
Yeah,
The constable is not in conformity of the rules because it's missing the notarized signature.
Any other objections?
No.
Okay. 7, 8, and 9 are admitted.
She's mad.
Mr. Canellis, do you have any other arguments or witnesses?
I do. I would like to ask Ms. Anderson some questions.
And Ms. Anderson has been previously sworn. You may go ahead.
Okay. Ms. Anderson, in Exhibit A in the affidavit that was submitted regarding the original petition, did you reside at the address where service was attempted at that time?
At that time for what?
For service.
For which?
For the original petition. The original petition filed on June the 3rd. Were you residing at the address?
Yes, I was residing at the address, but I did not receive any attempts of service.
Did anybody leave any documentation or?
No documentation.
Okay. So service was not effectuated on the original petition?
It was not.
Okay. On the first amended petition, and that is Exhibit 9 by the constable, did you reside at the residence that is cited in the affidavit?
I did.
Did you read the affidavit cited by the constable, submitted by the constable?
I did.
Did you see all the attempts that he made to reach you cited in the affidavit to provide you with service?
The attempts that some were fraudulent, yes, I did read. And some were not valid and some were inaccurate. Yes.
And you were not served by the constable with the first amended petition?
No.
The second amended petition, which is part of the business, or which is part of the amended business record affidavit, Exhibit 7, did you receive the second amended petition via certified mail?
The original was sent via email, and then I received it certified mail.
No. The second amended petition, did you receive that via certified mail?
I just confirmed that.
Okay, because you mentioned the original petition.
I said the original email for that petition, that amended petition, was sent via email. That's how I received it first, and then I received the certified.
Okay, you got the certified one.
And did you sign the green card?
Yes.
Okay, so you acknowledge receipt of the second amended petition on or about September the 29th?
I acknowledged receipt of the second amended petition. I do not acknowledge receipt of the original and the amended.
Okay.
The first amended.
Okay. I have no further questions regarding her acceptance of service.
Thank you. Does anybody on the board have any questions?
I do. How does the second amended petition differ from the original petition that was filed by the commission?
The hearing date is changed. It is our practice to file an original petition with a hearing date, and if service is not effectuated, then we file a first amended petition, and we call it amended because we changed the hearing date. And that's what happened, was that we did an original, setting it for July. That was not effectuated service. The first amended was for October, and no service was effectuated. The second amended petition, we filed it for the October hearing as well.
Is her firm really the BYOB firm? Or is that just a
when
name
we
for
mean amended petition, we mean the hearing date.
Okay, so other than the hearing date, was there anything substantively different in the amended petition versus the original petition?
No.
Okay, thank you.
Mr. Andrea, any questions?
No. Thank you.
And Ms. Anderson, since you're representing yourself, if you want to give brief argument or any exhibits, now would be the time for the jurisdictional issue only on the service.
One issue, well, one question that I mean, not a question, but one issue that I am not prepared to argue is I did not get an opportunity to have the proof of service for this constable made present to me or available to me till February the 10th, which would have afforded me the ability to contact this constable for the legitimacy of this attempted service to call them as a witness. That opportunity was taken from me to have a witness here regarding this particular matter that is jurisdictional and based and also potential criminal in nature. But to go back to the original, the argument aside, I never received notice of any potential service attempts from the original process server. I wasn't made aware.
I apologize, ma'am, to interrupt. I just want to point out, I think we lost the court reporter. She dropped off just as you were about to start.
Okay.
So I just want the record to be clear.
Let's take a brief 5-minute recess and see if we can get the court reporter back on.
Let's skip through a 5-minute recess.
Thanks, Matt.
Did anything happen during the recess? Because they're still there. They're not going anywhere. What is with their shirt? Is that actually the BYOB firm? Is that the name of her law firm?
The court reporter just texted me. She said her electricity went out, so I don't think her Wi-Fi or anything is working. So we might have to pause for a minute.
Okay.
It's a good day. I just ordered I ordered 200 feet of cable just now. 200 feet. It's my longest run I've ever ordered. Pretty excited about that. She also has a book by that name. Bring Your Own Brief. What kind of cable? It's I'll be here tomorrow even. It is Cat 8 shielded Ethernet cable. 26 AWG. High speed with RJ45 connectors on both ends. Indoor, outdoor, weatherproof. Bring your own BS. A little stubby. That might be accurate. Waiting for the power to come back on at the court clerk's office or the court recorder's house, whatever it is. Mommy Shar Shar, member for 16 months, says Happy Friday. Best place to be today and every day. We're watching this little hearing that went down Josh found for us. If you
think she's back.
Oh, is she back? Might start here in a minute.
There she is. I see
What's your
Miss
power
Kim.
bill each month? I could check.
Okay, I'm back. Sorry about that. I lost electricity, and when I did, everything went off. So
that's how it works.
Last thing that I got, this said the second amended petition, we filed it for the October hearing, and then I lost connection.
Okay, so Mr. Canales, so you said Mr. Canales was arguing that the second amended petition, and that's where you lost it, Ms. Ebert?
Yes. The last thing that I have that he says the first amended was for October and no service was effectuated. The second amended petition, we filed it for the October hearing, and then I got cut off.
Okay. So I believe Mr. Halstead asked a question about that. So Mr. Halstead, can you re-ask your question to Mr. Canales?
Yes. My question was whether or what difference there was between the second amended petition that was served and that you have proof of service by certified mail. How does that differ from the original petition? Are there any substantive differences?
Electric's about $250 to $300 a month.
The difference is the hearing date. It is our practice to file a petition with a hearing date. If service is not effectuated, we file an amended petition with an amended hearing date. That's why it's called an amended petition. But there is no substantive difference between the original petition and the second amended petition that Ms. Anderson acknowledged service.
Lindsay Lou, happy birthday to your son. Happy
thank you.
16th birthday, Ansley. Thanks for sharing with us.
Okay, Ms. Anderson, at this time, if you have any arguments since you're representing yourself that you'd like to make or any exhibits you'd like to offer, now would be the time.
I think it's appropriate to put on the record to request for leave due to counsel's inability to turn over relevant evidence that was needed in order for me to properly prepare. The particular evidence that counsel refused to turn over for 21 weeks was the proof of service from both the original process server and the second process server, which I wasn't even aware of the second process server through the 21 weeks of me asking for this information. The reason why leave would be needed is because I should be afforded the right to communicate with especially one particular process server due to the legitimacy of this particular document that is showing wasn't created until February the 10th, 2026. And the record on this particular document that has been admitted by counsel shows that this constable stated he turned this document in on August the 28th of 2025, which means that every request that I made, the over 19 requests that I made to counsel regarding providing me with this proof of service, he either had it or refused to turn it over so that I could properly inspect, because this wasn't a known issue that I addressed with counsel multiple times, or what the metadata is stating on this document, as it wasn't created until February 10th, 2026, is a deep concern, because I did not get the chance to identify these potential witnesses, to call them, to examine their testimony with the legitimacy of documents that could be criminal in nature. One, penalty against perjury. Two, an appearance of impropriety on counsel's behalf to withhold this particular document from me so that I could properly inspect. I did my due diligence to make sure that I asked counsel every email that is in the documents that I submitted, timeline, every single time, and counsel refused to turn it over. But he wants to lean on, this amended petition. If the amended petition didn't change anything but the date, then what was the issue of him turning this information over to me so that I can properly inspect? And this probably could be a mute issue. But now that these documents are showing to be fraudulent in nature based on the date that it was created and not the original date that they're saying that it was created, I need to request for leave, and I should be afforded that option, because I need to properly examine these particular individuals who turned these documents into the court that is appearing to be fraudulent.
And that request for leave is denied. The court has already, or the board has already heard testimony that you signed the green card for the second amended petition. If you have any other arguments or exhibits you'd like to offer at this time.
The rules state that the original petition attaches jurisdiction on a proceeding. The original petition, even with the date being changed, does not cause a significant amendment to change anything in the document. The original petition was not afforded to me from the original date that it was signed on June the 3rd. The first amended petition, which states that, it's another date that has been changed on this particular document, was not provided to me. This second amended petition, service did not properly attach because the original petition was never submitted or served upon me, which the Texas Code of Civil Procedure states, and this is also a part of the disciplinary board's rules, BOTA rules, that in order for service to be perfected, the original petition has to be served on the respondent. The original petition was never served on me. An amended petition does not, in return, negate and take place of the original petition. When I submitted my emails to council to turn over the original petition and proof of service, or this process needs to be started over so that I can properly be served the original, I wasn't given the ability to see the original, and council never told me that, oh, the only thing that changed was the date. I did not get afforded the ability to have these particular documents in my possession until February the 10th, which should be a big problem to the board that now, oh, I'm asking for this information for months, which he had in his possession, because even the original petition states that he had this document since February the 3rd. So I do not know if anything substantially changed, because it wasn't provided to me until February the 10th, along with the proof of service.
Ma'am, any other documents or arguments you'd like the board to consider?
Wow.
Let's see. Other arguments that I would like to present specifically in this matter. Hold on one second.
And we're going time. I'm going to ask you to keep it to 2 minutes or less at this point.
Under the due process, under the 14th Amendment of the United States Constitution, it requires not only notice of evidence, but a meaningful opportunity to review, investigate, and respond to evidence that directly affects a tribunal's authority to proceed. As I previously stated, counsel did a sneak attack to provide me with these documents on February the 10th, after I requested several times from September 4th, September 6th, September 8th, September 19th, September 25th, December 4th, December 5th, December 11th, December 12th, December 15th, December 16th, January 31st, 2026, February 6th, 2026. And counsel did not turn this information over to me until February the 10th, which is less than 48 hours ago. To now, I am being handicapped to properly vet this information that now calls into question my ability to put on a proper defense towards this particular matter. The late production is very prejudicial, and it comes as strategic, because if these documents was in counsel's possession the entire time, what was the reason he failed to turn this over for 21 weeks? I did not get to investigate the factual or the accuracy of these documents. I didn't get to evaluate. I didn't get to review. I didn't get to compare. I didn't get to have a meaningful jurisdictional response, because counsel turned this information over on February the 10th of 2026, 21 weeks later.
Thank you, Ms. Anderson. Does the board have any questions of Ms. Anderson?
So they tried to serve her with this, documented all the attempts.
At this time, we'll take the jurisdictional matter under a brief recess to go make a ruling on that. So if we can go off YouTube and be in breakout room.
Was that it? Or is there another one, Josh? Do we have to go to the second one? I think there might be a second one. Holy smokes. I think.
Evidence and testimony today, and we're going to go ahead and deny your motion to abate and move forward. This proceeding will be on the third amended petition filed on December 4th, 2025, and the board is taking judicial notice of the service documents on file and the green card that was attached to Petitioner's Exhibit 7 already admitted into evidence today. So I'll remind the parties that this is a compulsory discipline matter, which is an evidentiary hearing. All evidence need to be offered into evidence and witnesses need to be sworn. Ms. Anderson has previously been sworn. And Mr. Canales, would you like to make a brief opening statement regarding the compulsory discipline portion?
Yes.
Before I need to get on the record the basis of the denial of the abatements, especially because I have notified the tribunal of a fraudulent document that was presented and filed with the board that is committing perjury and should warrant an investigation, one of which I was not afforded because it was turned in on February the 10th.
Your objection is noted. We're moving forward on the compulsory issue.
So I don't get to get a response on the basis of the denial based on the lineage of fraudulent proceedings in this matter, because I would think that the board would take issue with the document that was presented February the 10th after being requested for 21 weeks, only for that document to be reported as being created on the 10th and not what it stated on August the 28th of 2025.
Your motion has been reviewed by the board with the pleadings and evidence and argument today, and your request is denied. We're moving forward on the compulsory issue.
So I don't get a response on the basis of why it was denied, on what grounds.
It's been denied. We're moving forward. Mr. Canales?
Thank you, Madam Chair. On or about May 21st, 2024, Ms. Anderson was charged with an indictment in United States versus Thelma Michelle Anderson, cause number 324-CR-00191-K in the United States District Court for the Northern District of Texas, Dallas Division, for allegedly engaging in unlawful activities regarding the Paycheck Protection Program, or the PPP. The PPP was a program that was implemented by the Small Business Administration during the COVID crisis to provide small businesses with forgivable loans, to pay for payroll and certain other expenses. Under the PPP, participating third-party lenders approved loan applications and dispersed the PPP loans to qualifying businesses. Respondent was indicted for intentionally engaging in wire fraud, 18 USC Section 1343, and for twice engaging in monetary transactions and property derived from unlawful activities under 18 USC Section 1957. On or about June the 27th, 2024, the respondent voluntarily pled guilty to one count in the indictment, and that is wire fraud, 18 USC Section 1343. Paragraph 12 of the plea agreement shows that this was done voluntarily and freely by Ms. Anderson. On July the 1st, 2024, Ms. Anderson signed a factual resume acknowledging that the government proved beyond a reasonable doubt the 4 elements of wire fraud. Element number 4 in the factual resume is that she intended to act with the specific intent to defraud. She voluntarily signed that factual resume. On March the 5th, 2025, she was sentenced, there was a judgment issued. She was sentenced to 4 years probation and also ordered to pay restitution of just over $20,000. At this time, Madam Chair, I would like to introduce the other exhibits that have not been introduced into evidence. But if I need to introduce all 10 of them, I would like to do it at this time to make sure that they're part of the record. I know that 3 have been introduced for jurisdictional purposes, but I would like to introduce all 10 of them that I have, if that's okay.
And are these the exhibits that were previously submitted on the exhibit list filed with the board on February 10th, 2026?
That is correct.
Ms. Anderson, have you received a copy of those exhibits?
The ones that were filed on February the 10th?
Yes, ma'am.
I believe so.
Okay.
Who's she
Ma'am, do you have
looking
any
at?
legal objections to the exhibits 1 through 10 being offered?
Hold on.
Hold on, let me check.
Option and completeness, because my legal objection is option and completeness because the record needs to reflect the full history of the reason why counsel is presenting the probation documents without the full record that is in existence for this particular criminal matter that is currently on appeal.
Ma'am, do you have additional records to offer at this time
Optional
under that
completeness?
rule and objection?
That he had counsel, you said, do I have any documents?
Yes, under the rule of total completeness, that's your opportunity. If you believe that there's something missing.
It's not on the respondent to provide. Counsel has possession and he has to submit because he has possession and he's cherry picking what he wants to put in on the record.
I'm overruling that objection. Do you have any other legal objections to exhibits 1 through 6 and exhibit 10 being admitted at this time?
That's my legal objection.
Okay. Exhibits 1 through 6 and exhibit 10 are admitted. Exhibits 7, 8, and 9 were previously admitted. Mr. Canales?
So she wants everything in instead of just what he's bringing in.
At this stage of the proceeding, what the commission is asking for is an interlocutory order of suspension pending resolution of Ms. Anderson's appeal. There is no dispute that Ms. Anderson has been convicted of an intentional crime, a serious crime of moral turpitude. There's no dispute of that. She admitted voluntarily that she intended to defraud, and she was convicted of that. There's also no dispute that she has appealed this case, and it is pending before the Fifth Circuit Court of Appeals. At this time, we're asking that under Rule 8.04, that the commission order an interlocutory order suspension pending the resolution of appeal, also in accordance with the board's internal rules 6.02. The commission has met its burden, and we ask that an order of interlocutory suspension be entered.
Any questions from Ms. Anderson?
In regards to this matter?
Yes.
Oh, you want about this?
Mr. Canales, during your investigation of this particular matter, in the factual resume that you entered into the record, did you review the entirety of the factual resume outside of just the signature?
I reviewed the elements of the offense in the factual resume.
So you did not review the objections in the factual resume?
I reviewed the entire factual resume and your signature admitting to meeting all the elements of what
objection non-responsive. Is there going to be a ruling?
I'm going to sustain that objection.
Sustain? Okay. Wow, she won one.
Ask your next question, Ms. Anderson.
Because you stated that you read the factual resume, Mr. Canales, the factual resume included a statement that the respondent was authorized to have outside employment in spite of the employer stating otherwise, correct?
I'm not aware of that provision.
But you stated you read it.
I read the factual resume and I read the
objection responsive. It's a yes or no question.
Ma'am, he said he didn't recall reading that statement. Your next question, please.
It wouldn't surprise you if that statement in the factual resume that is admitted into evidence is there.
Madam Chair, I'm going to object. I'm not a witness in this particular proceeding.
Am I getting questioned?
I'm an attorney for the commission. We submitted this document as provided by the court. Ms. Anderson does not dispute the authenticity of the factual resume. And
I think he said that
I'm going to
word
object to narrative.
It's an objection. Oh my goodness.
He was having his objection. His objection is sustained. Are there any other questions that you have?
Yes. I need to be allowed the ability to ask these particular questions because it is relevant, and the petitioner is relying on this particular piece of document, regardless of if it's a signature on it or not. These questions are relevant, and it's based on the exhibits that he has entered into evidence.
And ma'am, he is not a witness. So you have questions about the documents, basically.
Yes, the questions about reviewing the documents, he stated he reviewed it.
Okay.
There's a statement in there that contradicts the level of guilt that he's trying to present to the court. That means to the tribunal. So is that not relevant to act?
This is a compulsory hearing. We have very limited issues that are relevant for the court today. So Mr. Canales, I believe, has rested. Ms. Anderson, do you have any additional exhibits or argument that you'd like to make about the compulsory issue only?
Regarding asking him questions?
He is not a witness, ma'am. This is your opportunity. If you want to, representing yourself, make a statement, make an argument, or offer evidence of why this board shall not issue the interlocutory suspension.
I'm going to again re-urge my
legal
request
objection
for leave in this particular matter on the basis of, one, the issue with jurisdiction, in my inability to properly prepare when documents were presented less than 48 hours ago, that at that moment would have allowed me to seek counsel for this matter because of what has transpired with the late documents that has heightened the exposure of this particular matter, that has handicapped me from the ability to now seek additional help because counsel did not provide me with these documents so that I could properly prepare, as well as properly submit any additional outside witnesses for testimony, because this motion was filed and should have been heard prior to this proceeding.
Hang on.
That has severe.
The attorneys here, we have the defendant here.
We have audio.
We have the alternates in the courtroom.
Just 1 second.
And the foreman. I was handed a note which has now been marked CJ for court with jury exhibit number 1. The note reads, and I just want to go over it with you. It says all of the videos of car, and then it says back of the car, rear right. What I need more clarification as to exactly what you want. So here's what I'm going to ask you to do. Okay. If you want to tell me, you can. If you know, fine. If you don't know, I don't want you to guess. You can go back in. You can just rewrite this so it's a little bit more clear of exactly what you want. And then I'll bring all the jurors out and we'll tee it up for you and so that we can play it. We just weren't exactly sure. Sure. Okay. So I'll bring it. Get this back here. You just let me know and then we'll come back.
So we've got a question from the jury, a note from the jury. They're asking the video of the car, the back of the video of the car, specifically about the right rear. Apparently our jury foreman is illiterate. That was not a properly formatted question. Give me just a second here. Super Source Box 3 is going to be... Camera 2. Box 4 is going to be turned off. Box 1 is going to be...
Anna, you can go off until they knock on the door again. Thank you.
Okay, so just got it. This is our video. Sorry, we had to rebuild the whole of everything. The jury wants to see the back of the car. Let me tell you why this is important. The back of the car, they said, was a match because there was a distinct tail light out on the bottom right-hand side. I missed that during trial, but I heard it during closing. They apparently want to, they said, show us the tail light. We want all the videos. Show us the tail light. It's the Porsche Macan, right? I'm now thinking we might not get a verdict today. The jury's like, oh, you want a book, do you? Whose phone is that? If I were prosecutors, I'd be a little worried. The video of the car leaving his house and coming back. Yeah, we never have video to see who the driver is. But the gun that was used in the crime went back into his locked safe in the room where he turned the camera off a couple hours before. I mean, there's a lot. And yeah, I need to buy another taillight. Dang it! This one's probably going to be more expensive. No verdict yet. We just have a question, a juror's question. Came about an hour and 15 minutes into deliberation. They're asking to see the video of the car driving to and from, specifically the taillights. And this was a weaker part of the case for me. Yes, it does. I think it does prove that it was that car, but I don't know if the average viewer will look at these videos and put them together and say, oh, clearly that's the same car in this video as in that video. You need to have the map, you need to know the location, you need to know the timestamps, you need to sort of piece together clues to see how it's the same. It's not like a, you know, the Shaggy Wagon from Dumb and Dumber that just stands out, and where it goes, people are like, oh, it's that one. It's not that. Our verdict clocks are off by just a couple minutes. They started at 8 straight up. Started a little beyond that. Trying to see if anyone else has another clock that's you can split the difference on. Sloth Life member for 25 months, OG, as an attorney. Thank you very much, Sloth Life.
Remember in the beginning when we started 110 years ago?
It's been 25 months, been here since the defense opening in this trial. Yes, it's was a long time ago. Sloth Life, thank you very much for your support. And
Did you just use your words?
My son wants to thank you as well, and his daughter-in-law. Hold on.
Even a blind squirrel finds a nut every once in a while.
Let's see if we can.
You're comparing apples and orangutans here.
Yes, you are. In the silence, the mics are trying to find volume. They're trying to find voices in the court, and they're alternately turning up the sound until it gets too loud, then detecting there's no voice, and then turning it back down again. It's just an artifact of the sound system here. Okay, let's see if we've got a better note here.
So we're going to mark this as CJ-2. The jurors have sent out a second note when we asked for clarification. The note reads, side camera, 30 Green Grove Road, Porsche Macan returning from Colts Neck, right rear bumper light. They then send out S264, which shows that the Macan, and then in both, it shows the Macan at the lower part of the screen, and then on the top part of the screen it shows this surveillance. And then they send out 263 D.1, which is the surveillance that shows the back of a vehicle with the box around it. So I'm going to ask the state to tee up that video.
Just reiterate this mess alone, Mr. Murray. A chance to read it over one more time. Just for the record, Judge, it appears they're talking about 308 Green Grove. Yeah, that's what I read. It says 30. You said 30 Green Grove.
It does say 30.
It says 30 on it. Okay, but just for the record, there's 308 Green Grove, and then there's 32. But it appears what they're talking about is the car making a left onto Tilton Drive.
This one says 308 Green Grove.
Right, that's the video.
And this.
That's the driveway from 30. That's the two cameras. This is one camera from 308 Green Grove, and this is the other camera from 308 Green Grove. Do we all agree it's 308 Green Grove? I'll confirm with the foreman that that's what they want.
I think so. Both angles from 308 Green Grove. Right. I think that's probably the.
We're all in agreement?
Yeah.
Okay.
Just returning on both.
And we're talking about returning, like the 408 time frame. Can we bring the foreman back out, please?
We're just bringing the foreman out. Selena K, 34 months, OG. As an attorney as well, Selena, thank you for your support. Ruth Ann, member for 37 months, another
trying to be difficult.
OG.
So the note says side camera 30 Green Grove Road. There's a 308 Green Grove Road. And then there's a 30 Tilton. So we believe, based on the photos,
want to use that as a reference.
Of 264. So this is 308 Green Grove Road.
Yes, those are the ones we like to see.
Okay.
That page and the second page.
Okay. And do you want to see, so that we're clear, on S264?
This is weird.
Did you want to see the vehicle driving out and driving back, or just driving back?
Just driving back.
Okay.
This one? Just this.
Okay.
And this.
And that. So these are the videos that you want to see. And when you say this, it's 264. It's the second page. You pointed at the top where it says November 20th, 2018, 4:08 and 28 seconds.
This one.
Okay. And then the other one you pointed to is S263D1, which says November 20th, 2018, 2:07:55.
Correct.
All right. So that would be the one that's leaving.
Correct.
All right. So just the time frame of the back of the vehicle that you want to see. All right, we're going to tee that up. We'll bring you back out in a minute. We'll bring everybody out together. You can just let everyone know. Okay? Thank you, sir.
I don't know why we have the write us a note and send it using the bailiff system in place. If we could just drag a foreman out and just have a back and forth colloquy.
The two of you to look at it also to confirm what they're doing. I want you to be comfortable with exactly what's going to go on the screen. But Mr. Decker, I just want that area of time that they're asking for, the back of the vehicle. So it's probably not more than 5-7 seconds or whatever it is. It's not the entire video that they're asking for. They're asking for the back of the vehicle. All right?
Sir.
We're coming up on an hour and a half of deliberation time.
Can we mark this as a CJ2, please?
Sorry, did you have certain?
I'm blown away by that. I've got a question about this note. Just drag the foreman in here. Let me talk to him for a while. Now remember, this foreman was not chosen by the jury. This foreman was chosen by the judge. And it was chosen by chance because he happened to be in seat 1. There was no English writing skills test. There was no, other than basically, are you willing to be the foreman, which he might not have even known what that meant at the time. If this is the type of question we're going to get, we might be in for a rough ride. Don't try steak tartare despite what Thomas says. It's basically raw mince, usually with onions, capers, and a raw egg. I'm okay with the raw egg. I mean, I like eggnog. Isn't it have raw eggs in it? I don't like eat raw eggs purposefully, just straight, but somehow if you mix them up, it's okay, right? Juror number 9 is fuming. I could have done such a better job. It was a loaner vehicle. Paul's was in for service, right? But it doesn't matter. That particular fact doesn't matter. I wish we could get the audio here as well. We get a little gesturing back and forth, waiting for the jury to come in. Audio's back.
But they have not fixed.
Okay, so we just don't have live stream right now, so it is what it is.
I am media zone. I'm ready.
Can we ask the jury to come out, please?
Bye, folks. You're gonna come right and sit down. Doesn't matter where we sit. Yeah, just keep the grapes in here, please.
You're gonna go back to your regular seats.
Regular seats?
Yes, please.
Yeah, I'll be fine.
I just want to make, because I want you to focus. So you're good to okay.
Yeah, so thank you.
You're welcome. So for the record purposes, I had the foreman come out because I just wanted to clarify. CJ1 indicated all the videos of the car, back of the car, rear right. I had asked, and that came out at 8:50 a.m. I asked for clarification from the foreman. The foreman then went back in, he came back out, gave me a second note at 9:21 that says side camera 30 Green Grove Road, which is 308 Green Grove Road. It's 30 Tilton and then 308 Green Grove Road. It was clarified to me that you wanted 308 Green Grove Road. And then it says Porsche Macan returning from Colts Neck, right rear bumper light. And then I was supplied with S263D.1, which is the vehicle, a vehicle leaving on November 20th, 2018 at 2:07 and 55 seconds a.m. And then I was also given S264, the second page of that exhibit, which shows a vehicle returning on November 20th, 2018 at 4:08 and 28 seconds. So what I'm going to do is I'm going to play just that video surveillance from 3:08. It's about 15, 18 seconds going one way and then about the same amount of time coming back. So that's what I'm playing for you. That's what the foreman indicated. If for some reason I don't answer your question the way you needed it to be answered, all you have to do is tell me and I will fix it for you, okay?
Thank you.
All right. With that being said.
Can we approach for 1 second, Judge? I'm sorry.
All right.
All right, this is wild. It's like the court and the jury is learning how to do the whole jury-court interaction thing for the first time on this trial, and it's not smooth. I think we understand what we're looking at. I'd like to see what they're seeing here. Especially, it sounds like they're interested in that back right portion of the car. If there was a tail light out. But you've got to think, why would they be looking at this unless they're saying, what if it wasn't his car? I think this is a bad sign for the prosecution. I am Super T. It's every day's a struggle, but you're going to start seeing the effects of both financially and health-wise that outweigh some of that. So congratulations. That is awesome. 75 days. That is amazing. Why not have video playback capability in the deliberation room? This is the funny thing, Tumblr Troy. They do. They have a TV. They're just not allowed to use it. I have no idea why. If you're given the evidence and the way to look at it, but you have to come into court to look at your evidence, what happens if a juror's like, wait, slow that down. No, not that part. I was talking about right here. You have to go back and send another note back and forth. Laptop with the exhibits is typical. A clean laptop with nothing else on it. No internet access. I think it's bad for the prosecution because this was a open and shut case based on the evidence, and now the jury's questioning some of what I believe is the strongest evidence.
Okay. Yeah. I'm sorry. Let me just make sure, just hear me out. The original note says all the videos of car, back of the car, rear right. And then it says side camera, 30 Green Grove Road, Porsche Macan returning from Colts Neck, right rear bumper light. Now, when I was talking to you, when I showed you 263D1, that's that time frame, 11/20/2018, 2:07 and 55 seconds a.m. That's the car not returning. That's the car leaving. A car leaving.
Careful,
And
Judge.
then
You're testifying here.
11/20/2018, which is S264 at 4:08 and 28 seconds, is it coming back? Do you want coming back and leaving? Did you want both? Or did you only want the one of the car coming back, returning at 4 o'clock? If you don't know the answer yourself, I'm going to put you back into the jury room to confirm that, because it was my understanding when I first asked you, I asked you about both times, and I thought you meant that you wanted 2:07:55, the car leaving, because that's the picture you're showing me, and then 4:08:28 of the vehicle coming back. So I thought you wanted one going out, one coming back, but the same, these angles that you wanted. So I may be wrong. Do you need a minute to talk to everybody? Yeah. All right, alternates stay out here. Everybody else go back in the room. Just tell me what it is. I apologize. Here, sir, I'm going to give you your note back. Let me know.
So 2 notes, 1 colloquy, 1 failed exhibit session, and continued deliberation. We're going to get to the bottom of this first question that the jury has. Maybe we just need to hear it all again, Judge.
Be seated.
Maybe just start from the top. Prosecutors thinking, if only you'd admitted my PowerPoint into evidence, this would have shown them. This is so bad. This is terrible. Yeah. This is going to get quite messy if it continues along this path. And the judge, jumps the bench and hops down in the well. He's wandered around the defense and prosecution tables. He's almost got into the jury box as well. He's all over the place. This is going to ruin. This is why we can't have nice things, Sarah. Right now, we're still on track to finish by March 20th. But, they're going to get 1 replay. It's not a New Jersey thing, says Schmoopy. They're not all like this. I guess if this evidence that they're asking to see is very clear, if the video they're about to watch clearly shows the tail light out that the prosecutor mentioned in his closing, that was the first time I'd caught that in the trial. If it shows that, that's great for the prosecution. Wonderful. We've nailed it down. We know it's the car, because they're right now asking, is it the same car? That's why we're watching the videos. None of the videos show Paul driving. If you look close enough, you can't squint and see him. None of them have that. Becca, we're going to try to, as long as everything lines up here. The judge pointing out evidence, telling them, what you're seeing here is Paul's car driving to the crime scene. And then this one is where he's driving back. Excuse me? Excuse me? Squeeze me. Yeah. I do think it shows us the same car, but mostly it was the side view that gave me that. I never looked at the taillights and oh, yeah, the taillights. Maybe it's because I just didn't have it on a big enough screen, or I wasn't looking in the same place the prosecutor was. But he's like, see, notice the taillights? I'm like, yeah, they're red. He's like,
Remember
and then here?
In the beginning, when we started 110 years ago?
I'd like to know how many Porsche Macans with that model of trim are in the States. I mean, give them some space.
Even a blind squirrel finds a nut.
There's got to be a few, because he was in a rental, right? He was in a loaner car. I don't think it was like the dealership saying, here, you can have our unsold car, this new one on the lot. You can drive that around while we're fixing yours. I think it was like a rental car.
You're comparing apples and orangutans here.
Jury's back. We fixed the note, Your Honor. We've decided what we mean here.
This will be marked as CJ-3. It's
Third attempt, same question.
9:42 p.m. It says, showing vehicle going and returning from video 263 D1. Please freeze so we can the running lights.
See?
That's the way it reads. I'll show it to you. 2, returning vehicle from 263. M.1.
And the judge leaves the bench again. All right, it's not all the judge's fault. I'm going to blame the public school system in New Jersey, which apparently this juror is having a very difficult time formulating questions into questions.
Mr. Decker and Ms. Wallace, you guys can look over.
I don't think this is an ESL issue at all. We did hear the juror one's voice a little bit, and I believe he's a native English speaker. I just think he struggles to write. This might be the first time he's used a pen or pencil in years. Maybe let them text their notes in, Judge. That way the emojis would help us understand what they're asking
So
about.
it's this one here. That's what they're trying to depict here.
It's coming back. Right. So that doesn't seem like but I guess they're still looking for the driveway. Because that's referenced in previous notes.
At least if you let the jury take notes, you can tell which ones know how to write. Like,
I know, but we're not, they don't know.
if somebody just draws the whole time, you might not want to make them the foreman.
I'm giving them what they're asking for now.
We'll do this.
And if they want more, we'll give it to them.
Sure. We'll do these two.
Going and returning. So it's going and returning on 263 D1. So going out, coming back on this camera angle. And then the second one is, and then freeze frame, get like they asked for, and then returning vehicle on this. Just to show the back.
So it's both times for the front camera.
All right, then freeze. look at it, and then
Remember, through all this, we have 4 alternates who are sitting in a quiet room with no windows, not allowed to talk to each other about the case, but also have to be here in case something happens. And they get dragged in every time the jury has a question, so they can watch the evidence as well. So 16 people out in the hall right now. 2 groups, one of 4,
done,
one of
Mr.
12.
Murray and Miss Massalone, you can just give it back to me.
Okay. I just wanted to see the clips that they pulled up.
Of course you can. Of course you can. You can see, leave it there for that. Go ahead. Let them see it. Just let them see it.
Where are you going to freeze it?
The only time you see it's like right here.
Try to back it up right.
Yeah.
Right there. And we'll have all the lights off.
Oh, it's going to be dark. Nice. Just like we're in the theater, turn the lights off and get to watch the movie.
Yeah, of course. Do you need to put anything on the record?
No, I think we're in agreement with the flex.
Okay, so we're all in agreement. We have them both teed up. Stay.
One at a time, but yes. Yep.
Yeah. Sorry. Knock on the door.
Come on, folks.
Okay, I've got it on my big screen. I'll try to make heads or tails of this. I'm going to keep the timer going even though they're walking in and out of the courtroom because they're still in their heads. They're thinking about this. The deliberations are continuing. Looks like the defendant and the defense attorney coordinated their shirts.
942. I received the third note. Sorry, just want to make sure we have it right of exactly what you're asking for. This is and we marked it as CJ3. It says showing vehicle going and returning from video 263 D1. Please freeze so we can see the running lights. And then the second one is returning vehicle from 263 M1.1. So you can see that same, and you gave me a copy of 263 M.1. So we see that, we're going to show that, and we're also going to show 263 D.1, and we're going to stop it so that you'll be able to see it. So we'll do that now. If we could turn off all of the lights, please.
All the lights. The one going. And play.
Okay, you can unfreeze it.
Can you freeze it there?
Can go back a little bit. I just heard the jurors say that they wanted it paused again, so go back a little bit more. Back a little bit more. Tell us when to stop.
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 Right there. There, and then one more after that.
Like a second after.
A little bit further.
We're almost hearing them deliberate.
Further there. There.
They want the direct tail shot. We want to see how the car looks.
Okay, that was the area going out. Everyone good with going out? Now we're going to do the return.
They wanted a perfect profile rear view of the car coming back, going out. He signaled.
Pause. Do we have everything you need?
I do.
Yes. Okay. All right, ladies and gentlemen, you can go back and you can continue your deliberations. We can turn the lights back on, please. Yeah. And we can give them back these exhibits also. I'm just going to keep the note. Could you ask them to give us the other 2 notes back so that I have them secured, please? Thank you.
Apparently the jury room is literally attached to the courtroom.
Okay. Our alternates, you can go back to your location, please. Thank you so much.
Now we'll continue.
Good counsel, anything we need to put on the record?
No, Judge.
Okay. All right. Thank you all.
All right, so we're going to continue listening and monitoring that as we wait for updates, and we're going to go back to where we were on our little hearing, which we paused to get the question from the jury. Jury's now almost 2 hours into deliberation, so let's continue this little hearing where Miss Anderson is using all the words that she did not learn the meaning of in law school. Honestly, I watched this video. And I have to ask the question, is it easy to cheat on the bar exam? I don't know why that comes to mind, but that's what my head was thinking about as I watch this. So anyway, she did pass the bar, for those that are curious, not related to the previous question.
Disabled me from putting on a proper defense in this matter.
Your request for leave is denied. Ma'am, do you have any arguments or evidence in support of Rule 8.04 of the Texas Rules of Disciplinary Procedure?
For record purposes, what we are essentially here for today, the admission of guilt, which is currently under appeal. The existence of this case has been heavily documented under a current investigation for fraudulent documents that were presented to the grand jury that expedited a unlawful indictment.
Ma'am, I'm going to stop you. Ma'am, I'm going to stop you. We don't go into the merits on a compulsory issue. What we have to argue is under Rule 8.04. The petition and the board is aware that is under appeal. That is on the record. So is there any arguments you have for the compulsory issue of why the board should not temporarily suspend you while the appeal runs?
This interlocutory decision looks like it's moving forward, regardless of Miss Anderson and her big words. Hearing nothing. What, now she's giving him a silent treatment?
I'm going to again re-urge my request for leave because now, well, no, not just now, my inability to seek counsel in order for an attorney to take over this matter, one, due to the scheduling issue that was not addressed prior to this matter. So I'm going to again urge for leave because I need to get counsel based on the now heightened issues that are very much apparent and relevant in this matter.
The request is denied. Do you have any other arguments or evidence you'd like to offer to the board?
Why is my request denied for counsel?
It has been denied. The jurisdictional issue was ruled upon. We have proceeded on to the compulsory issue. This is your time to offer exhibits or argument for the compulsory issue only.
The jurisdictional yes was denied. However, I also brought up the date, the scheduling, that you all did not give me time based on the rescheduling and the new information that was provided on February 10th that now warrants my ability to get legal representation because new information was provided.
You chose pro se,
Your
ma'am.
request is denied. Do you have any additional argument or evidence in support of the compulsory discipline issue?
Is she typing in ChatGPT? If she starts asking if this is an admiralty court.
I need to request for a brief recess so that I can gather information that my computer needs to restart. It is stuck.
The board will take a 5-minute recess.
Oh, man.
I'm going to have to leave to restart my computer.
Please be back by 10:07, please. And are we off the record and stopping the stream?
Is that the last one? Is that the
We
end?
are off the record.
Thank you. Can we put Mr. Canales in a breakout room until we have Ms. Anderson back, please?
Thank you.
Thank you. I shall sit
Do you want
myself
me to
in the
go
corner.
too? Do y'all want to talk about anything?
I think we'll wait till we conclude the proceeding first.
Okay.
You just confirmed that the string is concluded.
It hasn't. Now it's about to, though. There it goes. Now it's done. I guess that's the end. I don't know if she ever came back. That's all we got. That's all there was. All right, Shannon, we were just watching a little interesting hearing. The hearing was basically a board, the bar, listening to complaints about a attorney who had agreed, had given a sworn statement saying that yes, she did falsify loan information for the PPP, the Paycheck Protection Plan program, during the COVID thing. It was a government funding thing. It's basically saying you defrauded the government. They're saying because she did that, we're having this meeting to ask for a interlocutory. What that is when the judge makes a ruling immediately without affecting the whole case, but it takes effect immediately. So it's like right now, it's sort of urgent. We take care of this, and that interlocutory is to stop her from being allowed to practice law as a lawyer, because believe it or not, she was a lawyer. So Yeah. Au pair sentencing in an hour and a half. Thank you, Mary, for that. We'll watch for that. Meanwhile, we're going to keep looking around the world of true crime to see if there's something else that we'd like to watch that might just be fascinating. We are approaching 2 hours. Let's see. Oh, there's Super Source. Why did that not work right? Let's see. 4. 3 is 4. Oh, I have to go there. There we go. There it is. 2 hours. Hit it right on the button. 2 hours of deliberation time. So, actually, let's put 4 is 4. 4 is 4 and 3 is off. Yep, now I'm gone. 4 is on. Okay. So many buttons. All right. She submitted more filings while being off the live. She never came back. They came back at 10:17. Good stuff. All right, let's take a look and see if some of our favorite. Let's see, we've got Tammy Rogers' personal room is live. Let's see, that's going to be on. It's on 6. Hello, ma'am. How you doing today? Got any cases for us? Can you explain thoughts on the taillights view? Natalie, it looks like the same car to me. Everything that I could see, it was really hard to see it. They were not good pictures, and it's in the dark. But everything I could see did show that it was probably the same vehicle. There's 1 or 2 views that are very clear that it is the same vehicle. The timeline, the location, the maps, that to me, even though it might be circumstantial to say, oh, and then this camera over here caught this, it adds up. The timeline adds up. Everything matches. I believe that it's the same car. I don't know what the jury was looking at. It sounded like they had a question about the taillight, possibly about one of the taillights being out. And they saw what they needed to see in that picture. I think it confirmed what I feel. So I think the jury's moving forward, possibly with a conviction. Good question, though. We already had one question, and it took 4 tries to get it in. And the jury in and out a couple times. Okay, ma'am, if you're not going to hold court, we're going to go somewhere else. I'm just saying. We're gonna bail. Let's see who else is live today. Judge Middleton's live, but it's landlord-tenant.
Oh, that's not set till 11. All right, so I have Esther Smedzik is here. Karen Hart is here. Miss Cleveland is here. And Dawn Heitker is not. So I have Bank of America versus Smedzik, or Discover versus Smedzik.
Yeah, I can't do landlord-tenant ones today. Sorry, I love Judge Middleton, but landlord-tenants, unless it's going to be something spicy, they're just tough. It's people in the worst situation of their life financially, about to lose the only stability they have. Minecraft Court has a live stream up, but nothing showing right now, so we'll keep an eye on that. See, Judge Simpson, he's also doing landlord-tenant stuff.
Coordinated entry resources. Their phone number is 734.
He's doing the preliminary stuff for his feed. So, Judge Wolf. Let's go to Judge Wolf in Tennessee. Heavenly Wood Courtroom.
I do. We have.
It looks like adoption.
He's my son. He's my son. Very much so.
It's either bring a kid to work day or this is a family legal. It looks quite pleasant and happy, so I'm thinking it's probably an adoption type situation going on. We'll let them enjoy their moment. Thank you, Judge Wolf. Let's see. 44th District. Anybody? While they're waiting to start, the latest on Nancy Guthrie.
Are you getting it?
The sheriff just is not working with the FBI apparently, and hasn't been the whole time.
Watching me.
How old is he if he was born? Oh, 9.
Not sure what Dylan's doing, but
Trooper, are you able to look it up?
His insurance?
Yes.
I am not. On the date of the stop, though, however, the vehicle was uninsured.
Right. It appears that.
So the proof of insurance wouldn't have been valid for the time of the stop.
Are you coming back to the Zoom, Mr. Hagar? Okay. Do you have a current certificate?
I think Mr. Cheeto Sky is crying.
Mr. Hagar, do you have a current certificate?
Yes, ma'am.
Yes, ma'am. Yes.
Okay, can you produce it?
Yes. It's on my phone. Yes.
Girlfriend.
Well, you'll have to start your video. Who's on the Zoom as iPhone 2?
Oh, that's me, Judge. Oh, just kidding. Stop me.
That's me.
Okay, who's me?
Oh, sorry. My name is Kylie Lotz.
Okay, thank you.
We're gonna zoom out if he starts to
He's
show
my
us.
846. We'll get you in. Okay, I just want to identify you.
Okay, I'm sorry. I didn't read the paper. I didn't know it was that early. I woke up late.
Okay, you're going to have to be more mindful, but I can fit you in.
Thank you.
Could you kindly? Okay, Mr. Hagar, I need you
Yes,
to be
ma'am.
prepared. This is a court hearing. Do you have
I am so sorry.
current proof of insurance?
Yes.
Can you show
Yes.
it to the screen?
We're gonna go out here on widescreen so you guys.
Okay,
don't see
read
it.
me the renewal date and the expiration date.
February 9th, 2026. And the expiration date is July 29th, 2026.
Okay, and what's the vehicle?
2016 Ford Fusion.
Okay, officer, on this first ticket, the A ticket, what's your choice on that? Are you denying responsibility, admitting responsibility with explanation, or just plain out admitting responsibility?
Admitting responsibility with explanation.
Okay, and the explanation is that you've now renewed it?
Yes, ma'am.
Okay,
My
Sergeant
grandpa-
James, pardon me?
Never mind. It's okay.
No, what were you going to say, sir? Something about my grandpa or my grandma?
Yeah, the day of the ticket, my grandpa renewed it, but it was under my mom's ex-boyfriend's insurance. But they broke up, so my grandpa renewed it and put in his name.
Okay, and are you living with your grandparents? Are they your caregivers?
Yes.
Okay.
My grandpa's right over there.
Okay. I'm glad that
Hey,
Grandpa's
Gramps.
helping you. Sergeant James, on behalf of this defendant driver, is
That was
there
actually a
anything
good
you would like the
explanation.
court to consider on the insurance ticket only?
I'd leave that up to your discretion, magistrate, if you're amenable to waiving it.
Okay, I am going to recommend you make a motion to dismiss since this gentleman has his grandpa helping him now, and it seemed like he may have gotten caught between relationships with his mother. He seems to be young. Any objection to dismissing it, Trooper?
Unfortunately, ma'am, per department policy, I'm not allowed to make a motion for that.
Okay. What's the
So,
policy?
we're not allowed to offer dismissal.
Okay, so there's no motion?
I can't offer a motion for dismissal.
What?
That's why I said at your discretion, if you're amenable to waiving it due to showing valid proof, I'm okay with that.
Okay, so the court waives the ticket
They changed their
because
policy.
defendant renewed.
They changed their policy to not allow officers to recommend
so
to
we'll
dismiss a ticket. Key sunsets for life. Thank you. Yeah, the previous
There'll be
lady.
no fines and costs on that first ticket, sir.
Didn't come back.
Okay? Do you understand that? There's no fines and costs on the insurance, but now we're going to go to your improper lane use ticket.
The judge.
What's your choice on that? Admit responsibility with explanation, or deny responsibility where I swear you in and we have an informal hearing. So are you going to admit that you did what the ticket says you did, or do you want to deny and say the trooper was wrong and the ticket's wrong and have a hearing?
Admit responsibility.
Wise
Okay,
choice.
with explanation? What would you like the trooper to hear about you and your driving habits? And in your explanation, you need to admit that what you did is wrong, how you treated him on the stop, and what you've learned. Okay, I don't know who you're talking to. Look at me.
I'm sorry, it's my grandpa.
Okay. I'm sure Grandpa's upset with you, isn't he?
Yes,
Are
ma'am.
you in a lot of trouble for the way you're driving?
Yes, ma'am.
How old are you on the day of this ticket?
16.
Okay. And I saw that the sergeant gave you a break on the side of the road because I don't think you were supposed to be driving at that time.
Amen.
Do you understand that laws apply to you no matter your age?
Yes.
It's a hard
Do you
truth.
understand why not driving like it's a video game or it's like an amusement ride?
GTA 5.
Do you understand why that's not appropriate?
Yes, ma'am.
Are you in trouble at home over this?
Yes, ma'am.
Blink twice if
What
you need
has
help.
happened at home because of this ticket?
My grandpa makes me, I'm not allowed to drive past like 7 o'clock. And I can only
You know
go to
what your
school and
grandpa
work and
should
back.
do? Your grandpa should do like my grandpa did and take me for driving lessons in the cemetery and the Macomb County Community College parking lot,
'Cause
where
then if you
you
hit
learn how
someone,
to
they're already
drive like
dead?
someone who can
What?
handle the responsibility of a car. Because, honestly, if you can't handle it
Driving
at
lessons
this
in the
age,
cemetery.
just don't drive. Okay? Because I read the remarks and the way you were driving, you really came on the radar of the sergeant, and no wonder. Just cutting across lanes and tailgating people. I mean, it doesn't seem like you're mature enough to drive. First of all, you're out driving when you're not supposed to be. And then you're driving like, it's like for fun. And you're going to hurt somebody. And I can tell your grandpa cares about you. He went out and insured the car. He's stepping up when mom's life didn't work out. He's standing next to you, looking over you and watching over you. He must wring his hands and say a million prayers when you leave the house. I would.
Or swear words.
Do you understand how dangerous your driving is? Do you comprehend that?
Yes, ma'am.
You do?
Yes.
Sergeant James, how did he treat you during the stop?
Mr. Hagar was respectful and understanding.
He
at the
was?
time. He was.
Okay, so do you think he understood the impact and the seriousness of this nutsy cuckoo driving?
I think between the two of us, magistrate, I think we might have driven the point home.
Tailgating the vehicle. I mean, lane change, far left to right. Learn what a blinker is. Learn what space is. Your grandpa should take you for driving lessons.
In
Like
the
seriously,
cemetery.
go to the cemetery and learn how to drive, because you are so young to be before the court with three violations in one stop, which means it was a doozy when Sergeant James saw you. Like you were sticking out like a sore thumb. Sergeant, anything you would like the court to consider on behalf of this very young
She's trying to get a
young
break
driver?
for him.
Yes, ma'am. Given
Hate to see it.
given all the circumstances, I'd like to offer a reduction for no points.
Okay, what would you like to offer this gentleman?
1 to 5 over.
Okay, so he's changing the ticket from a 2-point, sir, $130. He's making a motion to say you were speeding on the freeway, limited access on the freeway, 1 to 5 over, which is 0 points, but a fine of $130. Any objection to that?
We still get our money.
No, thank you.
No objection. But you say thank you for the courtesy, right?
Yes, thank you so
Okay,
much.
because he's giving you a break. All right. Do you have a job?
Yes,
What do you do?
I work for my dad's landscaping company.
Okay, so do you have any way to earn money in the winter?
Yes, ma'am.
Clear snow.
What do you do? Snow?
Yeah, we shovel snow.
Okay, where does dad live?
He lives in St. Clair Shores.
Okay, and are you with your dad's parents or your mom's grandparents?
My mom's dad.
Okay. Okay, I don't want them paying the fine for you. You have to learn that this is your responsibility. So how long do you need to come up with $130? It's your responsibility.
1 week.
Okay, the court will give you 7 days to pay. There's 3 ways to pay, Mr. Hagar. You can come into the court and pay at the counter. You can go online and we have a button on all paid and you can pay it there. Or you can, what's the other one? Mail us a check or money order. Okay, you have 3 ways to pay. You have 7 days to pay. And it's a total of $130 and I waived the fine on the other ticket. Okay? Would you like to thank the sergeant for doing you such a favor?
Yes, thank you so much.
Okay, thank you, Mr. Hagar. Thank you, Grandpa, for looking over and helping your grandson. You may both leave the Zoom. Thank you so much.
Let the beatings resume.
Thank you so much. Have a good day.
Okay, take care.
Trouble.
I'm way behind now. So I got to see where I am.
All righty, Magistrate. You have an excellent weekend.
Thank you. Thank you, Sergeant. Stay safe. 1 minute, I have a matter in the court.
Do you take a Cash App? Oh, man. All right, so the jury is still deliberating. They've now gone 2 hours and 17 minutes. They've had about 20 minutes or so to themselves since, maybe a little more than that, since they got the answer to the question about the taillights on the car driving by a 308 both directions. They got to pause it a couple times, look at the car, and then continue. They saw what they needed to see. What that means, we won't know until they come back with a verdict. But all right. Ma'am, you're muted.
You're muted, Magistrate.
I know, I'm just getting my docket in order.
Sorry.
That's a
Who
lawyer.
are we ready
That's a
on?
lawyer there on the bottom.
I have Mr. Anthony Williams.
Live from his
Okay,
closet.
and then, 1 second, everyone
Hang on, we've got
okay,
a spam
Mr.
call.
Williams is here, and Mr. Lotz.
Hello? 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 Are you there? Oh, they hung up. Sorry. Yeah, live
What did I just say
from
to
his
him?
closet.
Lots.
Okay, thank you. So we'll go to room 1. Mr. Steinberg, go to room 1. And then I'll be able to do all the arraignments when we come back, please. Okay, let's call this case number SP 4645459. This is the state of Michigan versus Kyle Anthony Kuffner. Both the trooper and Mr. Kuffner, please start. Okay, let's have your appearances, please. We'll start with the trooper.
Trooper Mason Loudermilk.
Okay, good morning, sir.
Good morning, ma'am.
Both
Your
from their
name?
cars.
Your name?
Kyle Kuffner.
Okay, thank you. This is the date and time set for the informal hearing on your ticket. Mr. Kuffner, you have to pick a choice on your ticket. You can admit responsibility where it goes to me to assess fines and costs.
From Providence, nobody to the post for processing.
I'm just going to mute you, Mr. Loudermilk. Oh, Trooper. Okay, and then you can admit responsibility with explanation. Both of those are where you're admitting to the court and to the trooper that you did what the ticket says you did. You were speeding in a construction zone. So if you admit those, we don't argue with the trooper. We don't get into it that he was wrong. And you, your party admission is binding upon you. If you admit responsibility with explanation, the trooper may, but is not obligated to make a motion to reduce the ticket to something less, either less fines and costs or less points. I cannot compel or order the trooper to do that. So know that if you admit responsibility or admit responsibility with explanation, you may exit the hearing with the ticket as written. The third option is you deny responsibility. That's where you're saying to the court and to the trooper that you didn't do what the ticket says you did. We have an informal hearing. I swear the parties in. I receive testimony and evidence. If I find at the end of that hearing by a preponderance of the evidence that's just a slight tipping of the scales that you did what the ticket says you did, I have to find you responsible. Going with an informal hearing is an all or nothing proposition. You will either leave the hearing with the ticket exactly as written or with no ticket at all. At the end of the informal hearing, if either side is dissatisfied with my ruling, you have an right of appeal and have a new hearing before the trial judge. However, if you admit responsibility or admit responsibility with explanation, you do not have a right of an appeal. You may try to set aside your party admission. You will have to file a motion. You will have to post a bond, and there's no guarantee that the motion will be granted. By proceeding today with an informal hearing, you give up your right to be represented by an attorney. You represent yourself. You give up your right to have this matter heard by a trial judge. I'm just the magistrate and or a jury. Having said all that, Mr. Kuffner, what is your choice on the speeding ticket?
I'd like to apologize with explanation.
Okay, admit responsibility with explanation. And what would you like the trooper to hear about you?
Hey, Trooper. I just wanted to start by saying I understand the importance of safety in construction zones, and I take responsibility for being more careful going forward. I work in medical device sales, and I was on my way to support a scheduled surgery that morning. Explains while I was traveling. I understand that doesn't excuse me exceeding the speed limit, and that I should have planned more conservatively on my time management. I rely heavily on my driving record for my job. I drive close to 50,000 miles a year, and I've taken this very seriously and made adjustments since the stop. I'm respectfully asking the court to consider my amending to a potential non-moving violation so I can resolve the matter responsibly without points.
Do you have a prepared statement?
I did.
Yes. My lawyer wrote that.
Okay.
He's pretty proud of that one.
I can't, Trooper, what say you? I'm going to ask you to unmute. I muted you before not to be rude, but I was getting your radio was coming in.
I understand.
Okay, Trooper,
I turned my radio
What say
down.
you?
Mr. Kuffner was very respectful on the stop the entire time, understood the mistake he made. It just so happened I was doing speed enforcement that day. I'm willing to reduce this ticket down to impeding, as he clearly came prepared to court, and his actions during the stop were also very commendable.
Okay, that's mind-blowing, because this ticket as written is a 5-point ticket and a $245 fine. And this trooper is making a motion to impeding. Any objection?
Down to 130?
No, thank you, Trooper. I truly
You admit
appreciate
responsibility to impeding?
I do.
Oh, man, clerk, did you take that other one back? I didn't do that part on the ticket. Okay. While you got a break from the trooper, I want you to understand that that's not par for the course. And if you rely upon your license for driving, then you should just drive responsibly. It's very clear that 696 is under construction. We're driving on the wrong side of the road. There's cement silos, okay? Medical jobs are important, but you're not that important. Those construction workers are putting themselves in a lot of danger. And it's absolutely like disgusting when I see tickets this high over. Okay, so he's going to give you a break. He has the discretion and the power. I mean, you were going 80, 81, 83. Okay, so he did write it up almost close to perfect what you were going, but you just can't drive like that,
No.
Mr. Kuffner. You just absolutely can. I mean, that was a nice spiel you gave. I hope it was genuine. And just, you know what I mean? This could have been even criminal what you were doing. So
Understand.
you admit responsibility for impeding?
Yes, I do.
Yes, okay. And the fines and costs for impeding is $175. How long do you need to pay?
A week. I'll have it paid today.
Okay, you can pay online, in person, or mail us a check. Okay.
In person, can I use a credit card, or do you only? Is it cash?
No, you can pay a credit card online. You can pay by
That way
credit
you can
card or
get
in
points in your
person
card
too.
without getting points in your
I'll
insurance.
be in Royal Oak later today. I will get that.
Okay.
paid.
Thank
I'll
you
just
so
zip
much.
over there through the construction zone.
Thank you,
Okay,
Trooper.
thanks.
Thank you, Your Honor. Appreciate it.
What a good deal. That's what
Am I
a
all
little
set? Can I leave the room?
You may go.
Thank
yes.
little time with Chat GPT can get you off the hook as
Thank
well.
you, ma'am. Have a good weekend.
Thanks. Okay, take care.
Where's our friend that was in the breakout room? Is he coming back? We are planning on going to the sentencing in about an hour for the au pair.
Okay. So who are we writing on first, please? Mr. Simon.
Williams was here before Lotz, so Williams is first, but then Mr. Lotz.
Okay, I still show that Mr. Shannon's in room 2, and I can't bring them back. Hang on.
You can close the
Mr.
room.
Shannon should have been he should have been cut out. He should have just ended that. We already did his information.
The door is ajar. I think Mr. Shannon ran. He's gone. Now we have Shannon, but not the judge. Okay, Shannon's gone. Judge is back. We're good.
Okay, thank you. I
care of
needed to clear out that video. Mr. Steinberg, are we ready on, is it Williams or who are we going?
Williams was here first.
Who did you go into our breakout room first with, please?
I've been with Mr. Williams and then Mr. Lotz.
Okay, we'll go with Mr. Williams. Calling the case number of 2600069. This is the case of the city of Royal Oak versus Anthony Williams. Where is Mr. Williams on the Zoom? Where'd he go? Okay, 1 second. Is he in a breakout room? Yes, he is. He's in room 4. Let's get him into the main session.
Might take 30 seconds or so. Close the breakout room. It'll kick him back.
Okay, Mr. Williams, can you please unmute yourself and start your video? Thank you so much. I'm so sorry for all that confusion. Okay, I'm calling the case again now that Mr. Williams has joined us. 2600069. This is the city of Royal Oak versus Anthony Dushawn Williams. Your appearances, please. When I say that, it means tell me your name. We'll start with the attorney and then the defendant.
Michael Alcember, P43481 on behalf of the defendant.
Okay, and defendant, tell me your name, please.
Anthony Williams.
Okay, and this is the date and time set for the arraignment. How are we proceeding today, counsel?
Good morning, Your Honor. I have gone over the nature of the offense of Mr. Williams' satisfaction, waived the reading therein, went over his constitutional rights as well, waived that reading, enter a plea of not guilty. We consent to being on Zoom.
Okay, I'll read the formal reading based upon your representations. Defendant pleads not guilty and not guilty plea shall enter. Is assigned counsel requested?
Yes, address was verified. The phone number was chatted to your clerk and in
Thank you.
69889.
Okay, and so Melrose is a good address?
Yes.
Okay, And what do you have to say about bond and bond conditions?
He owns his own business. It's landscaping. He's owned that business for 7 years. He is got 4 children. This is a first offense, no other offenses prior. I'd ask for a personal bond with conditions standard for somebody with a drunk driving offense.
Okay, so he also has suspended license, so I don't know if Operation Drive with the alcohol is going to work.
Actually, it might.
I know. I was thinking the same thing.
I just had that very recently.
In this court?
Yep.
What did the court do?
We gave him drive because, as you know, Judge Meinecke's very big about restoring licenses.
Right. So, I mean, how did they bifurcate it, or what did they do?
Well, he pled to impair, which obviously we recognized was going to impact his license, but then they were going.
While that was going on, you worked on the other violations?
He worked on clearing the rest of the stuff, yeah.
Okay. Okay.
Now I can't remember if it was Meinecke or Judge K, but I do remember the scenario.
Okay. So we conducting the arraignment, we waive the formal reading. Defendant pleads not guilty, and not guilty plea shall enter on his behalf. He shall have assigned counsel. We've confirmed his address on Melrose. It's Melrose Street, but I wanted to say Melrose Place, showing my age here.
I was going to say, I'd be
the
aging
phone
me
number
too.
was chatted, and the court is setting a $7,500 personal bond. No money's due at this time, sir. It's a personal bond, but if you violate bond conditions, that number may come into play later on down the line. And the conditions are as follows. You have to personally appear for any and all court events, sir, that have this case number and your name on them, whether they be pretrial conferences. If you do happen to be in Operation Drive, they have a lot of sentence reviews. So there's a lot going on with that, but in the end, it might prove to be for your benefit. But the bond condition is whatever court appearances there are that have your name on it, you have to be there, whether by Zoom like you're appearing today or in person as ordered by the court. You shall abide by any judgment entered in this case and surrender to serve any sentence imposed. You are not to commit any crime while released. You shall immediately notify the court in writing if your address changes from Melrose Place. What are the last 4 of the phone number? 6989. Or if the phone number changes from 6989. You are not to use alcohol, marijuana, or any other illegal controlled substance. You shall alcohol ETG test 3 times per month with pretrial services. Defendant must contact pretrial services by Tuesday, February 17, 2026 at 3:00 p.m. to set up testing. Sir, do you have a pen that you could take down the phone number?
Yeah, no, I couldn't take it down though.
Okay, I mean, you could write on your phone. Are you ready, please? Tell me when you're ready.
I'm ready.
Okay, the phone number is 248
248
451 2315. Ready? 248 451 2315. That's the number that you have to call before Tuesday at 3:00 to set up your alcohol testing. Okay?
Okay.
Now, a lot of people, like you seem to be on top of things, want to call today. They do not get the file from our court, does not go to pretrial service for 1 business day. So if you call today, they won't know who you are. If you call Monday morning, they won't know who you are. So you have Monday afternoon and Tuesday at 3:00 to call them to set up the testing. Okay, do you understand that?
Yes. So
Okay, we're going to set this for, what was your question, sir? I'm sorry.
Tuesday, 3:00.
You have to call by then.
Okay.
Set up the testing. We're going to set this for a pretrial. You have Judge K. Those pretrials are by Zoom, but you're going to get a notice to appear, and it's going to be a different Zoom ID than you used today. So make sure you look at the notice and Zoom in with the proper ID. Okay. And you will have assigned counsel representing you. It'll be you, Mr. Steinberg, right?
Yes, ma'am.
Okay. So Mr. Steinberg will be in touch with you. Mr. Steinberg, is there anything further requested
No,
or
ma'am.
required of the court on behalf of this gentleman, Mr. Williams?
No, ma'am.
Okay, Mr. Williams, this concludes the arraignment. You're free to leave the Zoom or you can stay and observe, your choice.
Okay.
Okay, thank you so much. The next person, Taylor Jones? Oh, no, Lots, right?
Lot. Yeah.
He's in a breakout room too.
And then you're going to go in a breakout room with 1001. Have we already done Taylor Jones? Have you spoken with Taylor Jones?
No, she
Okay,
was
we got a
due
lot of people
at-
here. Okay, calling the case number 26000061. This is the case of the city of Berkeley versus Hi Lee Ricardo Dwayne Lots. Your appearance, please.
Michael S. number P43481 on behalf of the defendant. He is, Mr. Lotz, state your name, please.
Lee Lots.
All right, Mr. Watts has
Good
been
morning,
advised.
sir.
Good morning, magistrate. Good morning.
Mr. Lotz has been advised of the nature of the offense so satisfactory, waive the reading therein, enter plea not guilty. He's also been advised of his constitutional rights as they apply today. We'll waive that reading. He consents to being on Zoom. His phone number ending in 0612 was chatted, and his address in Highland Park is confirmed.
Okay, thank you. Did you receive the chat? Okay, we haven't received the chat yet. Can I just have the phone number?
Oh, excuse me.
The phone number is 867-5309. That's 867-5309.
Highland Park is a good address for you, sir?
Yes, ma'am. 81 McLean.
Okay, thank you. And counsel, bond and bond conditions, what do you have to say?
Your Honor, it's almost academic. There's allegedly an outstanding ticket out of Highland Park. He lives in Highland Park. He actually paid it. So I've advised him that is what stands between him and a license. And I've advised him, because Highland Park isn't always the best at abstracting, that he needs to go down there and get a proof that he paid, and his next court date should be rather academic.
Okay, so that's great, but what do you have to say about bond and bond conditions? Are you saying it's...
I'd say give him a personal bond right now. He works at United Wholesale Mortgage, I think what used to be part of Rocket Mortgage, but he's a closer. He's been there 1 year. He pays his granddad rent. He's a really upstanding citizen. It seems that something got caught in the crosswires.
I have a copy of the driving report. I mean, it says it's suspended right now, but I don't know for what reason.
He thinks it's out of, he was told.
One second,
Told him when he
please.
pulled him over was Highland Park.
He had some suspension that was through 4/30/25. Then there's a return. I'm not sure here. Okay. So let's see. We're holding the arraignment. Waive the formal reading. He pleads not guilty. A not guilty plea shall enter. I've confirmed his address. I have his phone number. Is assigned counsel requested for this gentleman?
Yes, ma'am.
Okay, that's granted. Counsel shall be assigned.
Coming up on 2 hours and 40 minutes of deliberation. Just don't lose the number. Then they won't sing it. Let's see.
Okay, the court's bond is setting bond at $2,500 personal bond.
He's in a walk-in closet.
No money's due at this time with the following conditions, sir. You have to personally appear, whether by Zoom or in person, as ordered by the court for all court events. In this case, whether it be several pre-trials, sentence reviews, any further exams, you have to be there, okay?
We have a scam call.
And,
hang on. Hold, please.
you have to-
Hello? Hello?
Hi, this is Emily Wilson, and you asked me to call you back. Do you remember?
Who is this?
Hello? My name is Emily Wilson. Okay, I'm with U.S. Funeral Expenses, and based on our records, it shows that you may qualify for a state-regulated final expense.
This robot is so bad, it can't even sound normal. It's like merging sentences together with no breaks. Are there any people there? Can I talk to a person? Hello? Emily? Hung up. It knew how bad it was. Okay, we'll go back.
Is there anything further requested or required of the court on behalf of Mr. Lott's counsel?
No.
Okay, Mr. Lott's, that was a lot. Is there anything you need explained or further expanded upon?
Judge. Yes, please. You said you were going to send it to Highland Park. So for the pretrial, I need to report there, or do I report to?
No, the notice to appear, meaning I don't set the court date, so you're going to get a piece of paper like you did today for your arraignment. It's called a notice to appear at the top, and it'll set this matter for what's called a pretrial. You will have an attorney representing you, and it'll say pretrial, and then on your notice, you know how you had this for today, and it had enclosed for the Zoom. So it's going to be with the trial judge, not the magistrate. So you want to, on the date and time that it's set for, you want to log on to Judge K's courtroom. It's a different Zoom ID than you used today. Okay.
All right.
So you don't go to Highland Park. You can Zoom, like, are you at home or work right now?
I'm at home right now. Yes.
Okay, so you can Zoom in from home if that works for you. If you don't know how to Zoom in or you don't have the technology, you're always welcome to come to the court and we will set you up. Okay, sir?
Okay. Thank you. I just want to say thank you to you and Michael. That's my last comment. I appreciate
Thank you so
guys.
much. Good luck with this mortgage career. That sounds promising.
Yeah, I'm trying to be an account executive. Thank you.
Oh yeah, that's a lot of work. Yeah, that's a great goal. That you can have a great career there, I hear.
Yeah, it's lovely. And we used to be with United Shore, not Rocket Mortgage. That's
right. That was a big faux pas, right?
I got it wrong.
That's Ishbia's company, right?
Yeah, it's Matt
Ishbia with the big thing in Pontiac with the bridge. Okay. All right. Thank you.
All right. You guys have a lovely Friday.
You too.
The
Take
13th.
care. Be well. Okay. So who do we have next? We did Williams, correct?
I have to break out with Taylor Jones.
Okay, 1 second, because Taylor
break
Jones
out, then break up, right?
came after the gentleman at 10:01, and Jones came late, I think.
Yes, that's.
Hang on.
No, I was here on time.
Okay, you were here on time, so we're going to put you in a breakout room with Miss Jones. Sorry.
Thank you.
I don't always check everyone in, so I'm sorry, Miss Jones. Go to room 2. Mr. Steinberg, go to room 2. And then we will get the 10 o'clock. Did we do Robert Tate yet?
All right.
Okay, so we have Miss Jones. And then we're going to have Mr. Chutkowski. Our white steak.
He's in the closet saying he needs to break out. The jokes write themselves, but it's good. It's good. Hope he's successful. Yeah. Obviously, you don't want to get messed up in court, but it looks like he's straightened his ducks out, getting everything in order. Two hours, 35 minutes. I initially said 3. Do you think the jury can get it done in that time? Then they asked a question that took 45 minutes to answer. And I lost my faith in my own answer. So I'm worried about it being today now, but I'm sticking with my 3 hours. That's what I chose, 3 hours. I thought that it was hammered home to them. All right, we might jump to another court. This one's been fun, but Royal Oaks giving breaks on all their tickets today. I heard Judge Middleton took a civil thing up. Let's see if he's...
I'm going to shut this off and return it back into landmark tenant.
No. I just missed it. All right. Hang on. What is this? I gotta read this. Wow. Judge Wolf has gone all legal on his live streams. Doesn't want people to use them. I'm not sure if he understands what fair use is. Just because you own a copyright does not mean you can keep people from using it. But I guess that'll go to court and he'll be able to decide it. Judge Kristen Simmons back courtroom, back up a bit from where it is. Okay, let me do a quick search. Still have some time before Juliana. Judge Kristen D. Simmons courtroom.
The purchase price. It does not state any.
You said to back up a little bit from where we are. I'm not sure how far a little bit is.
Well, I think this is an EP. Been having so much fun with Tyler Smith. Maybe I'll have fun with George. I don't know.
George is fun. I think you're gonna have fun with George.
He's a character, that's for sure.
Everyone loves George.
Everyone loves George.
You and George. That's pretty fun.
Okay, let's let these two leave and see what happens next. Judge McBurney. I wish he'd fix his audio. It's a little better, but still, he talks in the mic like this.
What's the matter?
So, I was trying to stop. The attorney earlier said he had called. He did call me late.
Now you've gone too far back. Well, Josh, in my defense, you didn't tell me how far. You just said a little bit, and I measured. I measured a little bit. Let's go here.
Motion.
Judge, I have a consent judge.
Let's try this. Is it Bridge Day today? Change your backgrounds on Zoom, people. It's Bridge Day. Denmark just lost to Sweden in curling by 1 point. Oh.
Person, did you and Ms. Garcia work out a joint pretrial statement or a resolution?
Judge, I have a consent judgment that I can put on the record with Ms. Garcia when Ms. Garcia is ready to go on the record with you and I.
He's off the bridge. He's
Back on the
jumped.
record in LVNV funding versus Erica Garcia 25-03522. Counsel, can you put the terms of the consent judgment on the record?
Thank you, Judge. May it please the court. For the record, I am Attorney Richard Bruson. I am the attorney of record for the plaintiff, and my bar number is 35222.
He's
Judge.
reading this.
I can tell you that while the case was in recess, with the parties being in the breakout room, Ms. Garcia and I discussed the parameters of this case and have agreed
to enter into a consent judgment whereby judgment will enter in the amount of the complaint for a defaulted credit card assigned to the plaintiff, and that was in the sum of $598.15. I explained to Ms. Garcia that in Michigan courts and in Michigan law, there are what are called taxable costs. And I explained to Ms. Garcia what those meant. And in this case, they involve a $35 summons filing fee and a $37.93 summons service fee. And I explained to Ms. Garcia that by law, the legislature grants me a $75 statutory attorney fee concurrent with the entry of these sort of consent judgments, so that the total amount of the consent judgment, Your Honor, will be in the amount of $746.08. More importantly, I explained to Ms. Garcia that there will be concurrent with the entry of this consent judgment a $40 monthly installment order right on the face of the judgment, which will begin March 15th, 2026, and then each 15th day of the month thereafter. I explained to Ms. Garcia the best way to get those monthly payments to my office, and I verified with Ms. Garcia that her residence is still current for the purposes of having notices sent by the court to her Ontario Street address, which is on her answer to the complaint. Finally, Judge, as I explained to Ms. Garcia while the case in recess, as I do now, I asked Ms. Garcia's permission to sign her name to the proposed consent order with those terms.
He wrote this entire thing word
payment,
for word.
So that I can electronically file that with the clerk of the court by the end of business today. Your Honor, with that, I rest.
Okay, thank you. And that, Ms. Garcia, is accurate? Okay, you understand that you had the right to proceed to a trial in this matter? You want to waive that right? And you don't want to get an attorney to represent you, correct? Okay, and did you give the council permission to sign this agreement on your behalf?
Josh says I still need to fast forward more.
He asked if you can electronically sign it. Did you electronically sign
it? Defendant has made no showing or.
Let's go back. Is this the one?
To which the court is in receipt.
Is this him?
See.
Oh, that's him. See, I'm sitting on top of him, so I can't see him. Show me 7, 6, 5. There we go.
So that I can electronically file that with the clerk of the court by the end of business today. Your Honor, with that, I rest.
We didn't need to fast forward all. It's the next thing that comes up.
Thank you. And that, Ms. Garcia, is accurate? Okay, you understand
I'm going to move out of the way so you guys
had
can
the right to proceed to a trial in this matter? You want to waive that right? And you don't want to get an attorney to represent you, correct? Okay, and did you give the council permission to sign this agreement on your behalf? Or
I was gonna sign it. He asked if you can electronically sign it.
did you electronically sign it?
No, I don't.
Well,
You're
I think
asking her
this is an e-file court, so I expect it to be e-filed, with the court.
Okay, she said that you asked her if she could electronically sign it.
No,
Maybe he's asking for your, he's likely asking for your permission to put your signature on the document he just did.
Okay.
Okay,
Yeah.
did you give that permission?
Yes.
Okay, so he can electronically file it or go to me. I will review it to make sure it comports to what was stated on the record, and then I'll sign it, okay? Do you have any questions at this time?
No.
Any additional matters for the record?
Judge, at this point, the plaintiff rests.
Thank you, you're all set.
Thank you.
You're welcome.
Thank you, Ms. Garcia. Thank you, Your Honor.
Thank you. Okay, Spring Oaks Capital versus Curtis DeYoung, 25-04202.
Here we go. This is the one.
Michelle Bourne Fisher. Sorry, Michelle Bourne Fisher, P67527 on behalf of Spring Oaks Capital.
And your name, sir?
I am Curtis DeYoung, the defendant, appearing pro se.
Okay, today was the date that was scheduled for a motion for summary disposition, and then I think the defense filed a motion to strike pleading, to which I did receive responses for both. And the motion for summary disposition in response, so you filed Not a responsive motion, but a motion to strike the pleadings?
A motion to strike plaintiff's affidavit of accounts and exhibits to their motion for summary judgment.
Okay, and did you receive their response to your motion to strike?
I did not.
Okay, so they did file a response to your motion to strike, to which the court is in receipt. Let's see. When was that filed, counsel?
Well, there was he should have received his copy that was mailed out on the 10th. The court, there was an issue when we e-filed it. Apparently we filed our response and proof of service as one document. So it got kicked back, so we refiled, but it appears that you do have that.
So you just did it today.
Okay, so if he filed it on the 10th, he would not likely receive it because today's the 13th. It's possible they didn't get it.
Possible.
Okay. Okay, so you can respond on the record, counsel.
Respond to his motion to strike?
Yes.
Okay. So it's filed as a motion to strike, and I will address the motion to strike portion, but there are a lot of other things in his motion to strike which are not, they don't really go to MCR 2.115B. They're more so things that should have been raised as affirmative defenses in his initial pleading, and they were not. So those are waived. I'll note that the initial response to the complaint didn't comply with the court rules at all either. Regarding the motion to strike, the court rule indicates that the court may strike from a pleading redundant, immaterial, impertinent, scandalous, or indecent matter. Defendant has made no showing or offered any evidence that what we provided in our pleadings, both in our complaint and our motion for summary, would fit into those issues. If you'd like me to address the other things that he brought up, I can. But again, it's our position that those are defenses that should have been raised in the initial pleading and are such waived.
Thank you.
Yes, Your Honor. So thank you for the court's time. I'll keep this focused and rule-based. This motion is not about credibility or weighing evidence. It raises a threshold legal issue, whether the plaintiff's affidavit and exhibits are admissible at all. The controlling rule under MCR 2.116 G6, the court may consider only substantively admissible evidence at summary disposition. Under MCR 2.119 B1, an affidavit must be based on personal knowledge, set forth facts admissible in evidence, and affirmatively show the affiant's competence. As the Michigan Supreme Court held in Quanto versus Cross and Peters, the burden never shifts unless admissible evidence is first presented. And my first point that the affidavit must be stricken is that it's a failure of service. And
So it was a failure of service?
Yes, ma'am. And plaintiff's motion for summary disposition, they claim they followed the Michigan court rules and filed the affidavit with the complaint. However, my complaint did not contain that affidavit. Also, I came up here February 2nd prior to filing my motion to strike and spoke with the clerk and asked them to print me off a copy of the original complaint that was filed by the plaintiff. And that too did not include the affidavit.
You might have a case
where their three arguments in their summary disposition are based on filing a counter affidavit, consent to amount sum, and account stated. And all three of those arguments are mischaracterized directly.
Okay. And did you want to respond to the statement that was made in their response to your motion to strike, which is essentially your response to their summary disposition really reads like it's something that you should have filed when you filed your answer, which was your answer in affirmative defenses.
Right. I disputed in my affidavit, which was my answer here with the complaint. I cannot file a counter affidavit to an affidavit that was not filed with the complaint. So but however, I did file the affidavit without their copy of their affidavit. And I can read it for the record, which clearly disputes their claim here. On January 23rd of 2022, I disputed this account with a previous debt collection agency. After the dispute, the agency that was being disputed stopped reporting, stopped contacting me. The plaintiff with Spring Oaks Capital, their bill of sale does not show any information pertaining to the account that is mentioned in the claim. There is no signed contract between the defendant and their claim and the claimant. I did not consent to a sum due. There is no written or verbal consent. I did not authorize Spring Oaks Capital to purchase or buy a debt. I have not received periodic billing statements during this question. In question, I was living in a different area at that time. I did not have an active phone and could not be reached at that time either. Spring Oaks Capital has not reported on my credit report until May of 2025. Soon after this time period, they filed the suit. Their bill of sale, Your Honor, predates the creation of the original creditor's account. So how can you transfer, assign, or sell something that does not yet exist? Their purchase agreement has a cutoff date of June, I believe it's June of 2022, or July 20th of 2022. However, the assignment says July 28th of 2022. You cannot assign something that's, the document's already been cut off. You can't assign something after that date. The purchase agreement is also signed by Spring Oaks Capital SPV and Spring Oaks Capital LLC, which is an internal transfer and is signed by the same president and CEO. It's not a transfer from the original creditor to the plaintiff here.
Okay, so let me stop you. Are you disputing the validity of the transfer or the validity of the actual original debt? Because you say you disputed it on your credit report with another creditor?
Yes, it was reported on my credit report by a Tombstone Bank of Missouri.
Okay.
I disputed it with them.
Why was that?
Why was that? That account is not mine. I did not.
You never opened any such account?
I'm not here to dispute that.
No, you're here to answer my question. So you never opened any such account is what you're saying?
Not with the plaintiff, no, ma'am.
No, that's not what I asked you. I'm asking you about what you disputed.
That
you brought up in this court. I didn't bring that up, you did. So you say you
I disputed that I never opened up
an
account with Tombstone.
With Tombstone, okay. Okay, so the original, let me open the original complaint.
He's well informed. He knows the law. I wonder what his background is legally, because he's making good arguments. He's citing case law that's foundational. It's not like deep Westlaw research, but business law type stuff. The dates, they're little things, but it makes a big deal.
The original complaint states or alleges that you had an account with the Bank of Missouri. Is that accurate?
They said I opened it.
No, I'm asking you a question. Is that accurate?
I did open an account
with Bank of Missouri.
Through Genesis FS Card Services.
Okay.
That's who I got the open an account with.
Okay. I'm trying to figure out where your dispute it triggers. Is it you're disputing that they now own this debt?
They do not own it.
You answer the question. You can't tell me if they own it or not. Are you disputing that? Because that's a question. I got to decide that.
I'm disputing that Spring Oaks Capital SPV does not own this debt, and all of their exhibits contradict their claim.
Okay, thank you. Counsel, did you want to respond?
Yes, I'm showing that this account was opened on October 27th of 21. If you'll see the bills of sale we attached, let me get the date. July 28th of 22. So the bill of sale doesn't predate the opening of the account.
It does.
It does, he says.
Can I respond to that?
You may.
Okay, their bill of sale has a closing date of July 28th of 2022. This bill of sale is between Genesis F Card Services in consideration of the purchase price. It does not state any of the defendant's name, account, or anything. It is generic files.
Does it have account number on there?
It does not. It does not have the defendant's account name.
Can you show me what he's looking at, please?
So it sounds
Okay,
like
so you're seeing a bill
he
of
might have
sale.
incurred
And
this
so
debt, but he's disputing
this is from
this
an
collector.
agreement from June 8th, 2021. Receivable sale agreement dated June 8th, 2021. Bill of sale closing date July 28th, 2022.
Is that the bailiff?
Genesis Card Services. What is the issue? You're saying that the
defendant's account is not mentioned in the sale at all. And I have case law or statutes that state that generic files are not admissible evidence to.
Okay, well then all this does is create a question of fact. It doesn't.
Material fact, right?
Yeah, so first, as it relates to your motion to strike, I'm denying that. We're not just striking their pleadings based on the fact that you have some affirmative or what you believe to be affirmative defenses. You can present those at the time of trial, okay? So your motion to strike is denied. As it relates to their motion for summary disposition, I think that obviously you've got some evidence that you believe poses a question of the fact that the court needs to hear further on. So I don't think that this is right for disposition. I think this matter needs to continue. I'm denying the motion for summary disposition. Is there already a trial date on this?
It was today.
No, today was the trial date.
At 1:30.
At 1:30.
Your Honor, is it possible for me
Ready
to
to see today?
Is it possible
You can respond.
to respond to, so when he talks about the bill of sale, there's a schedule attached, which does have his specific account information.
Okay.
We also attached to our motion for summary disposition is the affidavit of ownership and indebtedness. So I don't believe that's an issue.
That was not filed with the complaint.
It doesn't have to be.
They state under Michigan court rules.
I've already made a ruling. That you all gonna be here at 1:30 for trial? Because we're not taking up any more time this morning for this.
Yes, ma'am.
Counsel?
He lost. That switched fast. I'll be here at trial.
1:30 for Bayshore?
I would ask for an adjournment, Your Honor.
Oh, now
I'm
you're
ready for trial, ma'am.
Today's the date and time scheduled for trial, so we can't just adjourn. For what reason?
Well, for the reason it should be his answer, nothing so far that defendant has presented. He's raising affirmative defenses now that have all been waived.
No, they have not. You waived them, and I have.
Do you all want to talk privately to see about this? Because that's what you're talking to.
No, ma'am, I'm ready for trial.
Okay.
Can I bring up, I'm sorry to cut you off. Their witness list, it's Jane Doe and John Doe. How do I cross-examine witnesses in trial? They do not have a valid witness.
Are you expecting witnesses to appear at your trial, counsel?
No, I don't believe we are.
Okay, the witness does say a representative from Spring Oaks and a representative from Spring Oaks. So that was just in case that you believe that you were going to have to call a witness. Well, I guess you would likely have to call one. Let's see, and you intend to call the defendant as a witness?
Correct.
Okay, let's see.
I don't see, did Mr. DeYoung file a witness list and exhibit list?
File a witness list or exhibit list?
No.
Did you have to file an exhibit list?
I did not file an exhibit list.
Did you give them a copy of your exhibits?
I mailed them a copy of what the court has on file now.
No, Your Honor.
You mailed them a copy of your exhibit list?
No, ma'am.
I issued a pretrial order stating that they needed to be exchanged 1 week prior to trial.
He might win again.
Well, the plaintiff's complaint is.
I'm not talking about the complaint.
Well, I didn't.
Talking about your exhibit list, because you have some exhibits there.
I just going off what the complaint is. That's all I'm going off of.
Well,
Their bill of sales.
For you to make a defense, you're gonna have to admit some evidence. You have exhibits to admit as evidence?
Yes, ma'am.
That's what I'm saying. You were
Can I enter those today?
You can give them to her today. You can't enter them until they're properly transferred to her. Just like she's got to give you a exhibit list, you had to give her one too. Hi, everyone. And you're not calling any witnesses I'm assuming you're going to call yourself?
Yes, ma'am.
Okay. I'll reset the trial. You're not prepared.
He almost won because she wasn't prepared either, and she would have to fold. But now,
So right now I'm just lacking the exhibit list, ma'am.
Provide them with an exhibit list, and if you have a witness list, that as well.
okay. All right. A little spicy back and forth. I wonder if he had worded that differently, if it would have been okay. If he had said, I'm only using their own exhibits for evidence.
March 30th at 9. Does March 30th work for you, counsel, at 9?
Yes.
Okay, we'll do March 30th at 9 a.m.
I do have a question too, if I may.
Fire away.
Yes.
I know that you denied defendant's motion to strike. So first, I need to know who's going to prepare the order for that.
If you can prepare an order denying both the motion to strike and the summary disposition, that'll satisfy both.
And my second question is, because there's been no written response to our motion for summary, are we able to, before the next trial date, file another motion for summary under 2.116 G4? His failure to respond in writing, our motion for summary should be granted.
Yes, you can file another.
I did file a response in opposition to plaintiff's motion for summary disposition.
I did not receive that. If you did.
I mailed them a copy of
let's see. I see your motion to strike. I don't see any other filing since then.
It was all one packet.
It sounds like this guy actually incurred the debt, and he's just disputing the fact that this debt collector has come into ownership of the debt and is trying to collect it. Saying, I never had a deal with you. And he's using sloppy paperwork and
a defendant's reply in support of motion to strike and in opposition to plaintiff's motion for summary disposition.
Is that one document? I have defendant's motion. Right.
It's one document.
Is that what you have was filed with the court? My filing with the court says defendant's motion to strike plaintiff's affidavit and exhibits. There's no mention of a response to our motion for summary. So is this a new document that he?
No, this actually this is in here. This was they entered it into my file separately. So one, it looks like they entered as a motion, the motion to strike, and then attached this as the brief to that motion. So under the brief, it was the defendant's reply in support of motion to strike and in opposition to plaintiff's motion for summary disposition.
Okay, I do not have.
I do see that in my file. They filed it as a brief, although it's really not a brief, but. Okay, let's see. We'll do March 30th, 9 a.m. We'll get you a notice to appear. I'm just gonna scan this. Counsel, I still will allow you to file another response, motion for summary.
Okay, thank you.
Prior to that date. Any additional matters for this record?
No, well, just a question on the date. So when she files her summary disposition, that's going to be filed within 7 days of trial?
That'll be filed prior to the 30th, because if she files it, we're going to have to hold the hearing on the 30th. she needs to get that to you, I think 7 days prior, to get you an opportunity to respond. You'll also probably be receiving their response to your motion to strike at some point, because it looks like they just filed or sent that response to you. So you'll be getting that as well. So counsel, you think if you're going to file a motion, another motion for summary, that you will have that filed no later than the 23rd of March?
No, absolutely, yeah, we'll have it
And they
before.
can use their same exhibits on the next summary disposition.
They can use this, they don't need to file a new exhibit list. They're all set. Okay. Yep, they're all set.
Thank you, ma'am.
Thank you. Thank you,
All right.
counsel.
That was a fun one.
Thank
As we
you.
wait for
Have a good day.
the sentencing for the au pair to begin.
Let's see.
All right, let's see if we can get that lined up. We've got a little bit of time here, about another 15 minutes or so before that begins. But let's see what we got. Let's turn this one off. Okay. This courtroom looks familiar, doesn't it? There we go. Let's go back down to the little corner where I belong. There we go. All right, all is right in the world again as we get set for the au pair sentencing here. This is back to the murder trial that we watched before, the one we watched just now, the one we're in verdict watch for. So we are about to hear sentencing in a trial where the defendant, the au pair, pled guilty, turned state's witness, testified against Brendan Banfield, and now is hopefully, according to her, well, at least I think she's hoping that she's going to get the deal that she signed up for, which could be considered a very sweet deal. The judge has the ability to decide some of those factors in that agreement and choose within a range of penalties as far as time that she has to serve. Can we get a poll for sentencing time? I don't know the full range. I've heard it can be as much as 10 years. I'm pretty sure it's going to be an all or nothing, though. Will there be victim impact statements? Possibly. I don't know on this one. I think there will be for Brendan, so it's possible they will here as well. Let me fix this overlay. Just 1 second. There we go. All right. No, you did not miss the sentencing. It's happening right here. Let's see if we can add this to the description, though, so people can find it. All right. The time is 11:20. I've passed the 3 hours of deliberation mark. No new questions yet from anyone in our other court, which we're keeping an eye on as well. So this is weird. A throwback to the court we just finished, the Virginia seals. It's throwing me off a little bit. Brendan Banfield's accused of killing two people, Christine, his wife, and Joseph Ryan, who was lured via a risque website to the family home as a means to continue an affair with the au pair. Red Pen, that is a great summation. The murder happened February 24th, I believe, which is the day after Brendan Banfield's birthday. Police found them fatally wounded in the Banfield's home. And Juliana was charged less than a week later, and a year later, Brendan was charged. Juliana sat in jail for the entire time since then. If they can prove she lied, can they throw the deal out and give her real time? Barb, I don't think there's any effort to do that. I think the state is very happy with what they got from Juliana. They got them the conviction they were looking for. She testified consistently with what she said before. They're happy. They're not going to be like investigating to see if something they told that she said both initially and later was a lie. She did her part. That's why we've got the sentencing now. She's completed her part of the deal. If a verdict came, would we ditch sentencing? No, we'd probably go to a 2-box and turn both audios on. I'd put the au pair in the left ear, and the Paul Caneiro in the right ear, and you just have to choose which headphone you want to listen to. No, I wouldn't do that. We'd probably pause one. My opinion, she needs to serve more time before she's deported. Deportation is something that is going to happen. It's an eventuality in this. We just don't know how long. Will there be any taillight questions? We had taillight questions in the Paul Caneiro trial this morning. Took about 45 minutes to sort out. The jury wanted to see the taillight. It was crazy. New Jersey, do better. Red Pen says, my brain would explode. Got a call coming in. Hang on. He hung up. Ivan, are you there? Hello, Ivan. Can you hear me? Let's try this again. Ivan, can you... No, he's gone. I tried, Ivan. I tried. I pushed the right buttons, then it just stopped working. When deported, will she do any time in Brazil? No. Brazil doesn't have anything against her. We don't have some sort of agreements where like, hey, send them over here. We'll just hold them in prison. If she gets to Brazil, she's basically out to live as she chooses, and then to make money as she chooses with the deals she's brokered while in jail. I haven't tried calling, but I didn't get through. I tried answering. They wouldn't have gotten a conviction without her. I believe that's correct. Has Brandon been sentenced? No, that's coming later. Nurse, don't apologize for being in class. Good job getting education and furthering yourself. The feds intercepted my call. It happens. It happens. Try again. Use the burner phone. Don't know why the court doesn't let the jurors play the videos. The court does a couple things that nobody else does. Let's see. She'll be a celebrity in Brazil. I don't know if it's celebrity, but she might end up with a lot of money in Brazil, which lets you live the life of a celebrity, I guess. Alvaro Zignani. Did I say that right? Glad you got a free membership. Okay, we're just in a holding pattern. We have about 5 minutes before we expect this trial to start, or the sentencing to start for the au pair. It'll be interesting to see her at the defense table instead of seeing her on the witness stand, which we saw in the Brendan trial. It was some gripping testimony that we heard from her. And a lot of attitude. I also want to see if she appears similar to how she appeared when she testified. Her appearance was very different than how she was videotaped and recorded. Here's Ayden trying again. Got another quarter in the machine. It might be on my end, Ayden. Hang on. Let's see. Are you there? Hello? Ayden, it says you're there, but I just can't hear you. Can you hear me? Okay, now I have a prank call, and it's not coming through either. What is wrong? Okay, I think it's fixed now, whatever it was. Got some sound from court. Rob, how's it going, Rob? We're back up in your neck of the woods for the au pair sentencing. I'm guessing if you're here and chat with us, you're not also in the courtroom. But hope you're doing well. Here's the question on everyone's minds. Will there be an FNF tonight? It might be too early to tell. I know with work that runs late, sometimes it's a last-minute decision. Not worth the trip when it's live streamed. Yeah. The verdict watch we've got going in the corner, that is for the Paul Caneiro trial. That's the brother accused of eliminating his brother and his brother's family, burning their house down, then lighting his own house on fire. So that jury is continuing to deliberate. They started this morning after listening to 9 hours of closing arguments, possibly some of the worst closing arguments I've heard. Bailiffs in the Virginia courtroom telling the gallery what the rules are. Don't follow it, and you will be kicked out. Might be a bit early to tell, but I was planning on FNF. That'd be awesome. Are you covering the Faust? It's a bit too spicy for this channel to cover. Some of the facts are a little much, but I've heard that judge is something else in the Georgia v. Faust. 9 hours is insane. The way it broke down, we sat through 3.5 hours of the defense closing, which the defense goes first, and then in this courtroom in Virginia, defense goes first, and then the state. It's not bifurcated, and the state goes first, then defense, and the state goes second, which we're sort of used to. Defense went first, and so they don't know what the state's going to say. And they spent so much time telling us what the state's going to say. It was almost like we were getting a preview to the state's closing. And obviously they used, as they do, a terrible PowerPoint, black and white, tiny font, tons of letters on way too many pages. And then we read them. We read them and read them and read them. It was bad. We thought it was the worst we'd ever heard. And then the state gets up and says, "Hold my beer. Watch what we can do." And they gave us 2 hours and 20 minutes or something the first 2.5 hours the first day, and then another nearly 2.5 hours the second day. And well, it might have been more than that, because we ended up with 5 hours and 25 minutes for the state, and just PowerPoint that never ended. Tons of tiny font. They added red text to make it better. They added a few videos. That was helpful. But then when the state was doing their closing, they were introducing reasonable doubt, presenting for the first time possibilities of what might have happened with this gas can and how and when Paul might have done something when there was no evidence ever provided at court or even teased in an opening as to how that occurred. And That's just introducing reasonable doubt or introducing a theory that counters whatever theory the jury might have come up with in their head as they've listened to this evidence, saying, yeah, I see how that makes sense. And now you come in with something else that doesn't, that now they're going to be doubting themselves. It's like they switched roles. Yeah. Rob, it was long, 5 hours and 25 minutes for the state. I forget how many pages in the PowerPoint it was, but it was somewhere like upwards of 125 pages. And it rambled. It was not chronological. It didn't start from the beginning and build the case. It was, I don't know how many times we revisited the trauma of the children. And this is serious. I mean, this has an impact on the jury, but the think of the children moment that would just come at random times during the closing, and then a pause, and now on to the car. It's just like, what? I said my worst fear. My worst fear is that he's going to get convicted, and that prosecutor's going to think it's going to be because of his closing.
Quick matter.
And he's going to put some other poor jury through it. All right.
Judge, did you want to do that before or after? Yeah, let's just do that right now. All right, because Mr. Carroll, I think, is here. Mr. Carroll, if you want to come forward, just on the case of Commonwealth versus Brendan Banfield, Mr. Banfield's presence has been waived. Mr. Carroll is present. Commonwealth is present. This comes on your Commonwealth's motion to seal 2 of the defense exhibits, correct?
Judge, yes, 2 exhibits, and we're actually going to orally add 2 more. We have been approached by Mr. Phillips, representing Inova Hospital and a member of the public, about another case that includes, another exhibit that includes personal information. So the defense exhibits we would ask to seal are 120,
right,
121,
okay,
122, and 123.
Right, and that has protected patent information, is that correct?
Protected health information or protected personal information.
That was already public.
All right, okay, so I got you.
It's already out on the website.
No objection, Judge.
All right, we'll go ahead and seal those for, I assume there's many patient information in there, is that what it is?
There, yes.
Okay, so 120, 121, 122, and 123, correct?
Yes.
All right, I'll grant your motion. That's fine. Thank you, Mr. Carroll.
Thank you, Judge.
All right.
Grab your copy now before it's sealed. Au pair's going to be brought in right now.
Campbell. Thank you.
This is the au pair's attorney, Mr. Campbell. He got his client a sweet plea deal. Let's see if the judge honors everything. So they did seal some of the Banfield files very quickly. Two more. They've been out forever, so people have copies of them, but they're going to be sealed going forward. Ooh.
All right, the case of Commonwealth of Virginia versus Juliana Perez-Magalhaes. Ms. Perez-Magalhaes is present in the courtroom with her attorney. The Commonwealth is present. Comes today for sentencing. Are we ready to go forward today, Mr. Campbell?
Yes, Your Honor.
All right, have you reviewed the pre-sentence investigation report with your client?
We did, Your Honor. No changes, additions, or corrections.
All right, does the Commonwealth have any?
No changes, additions, or corrections.
All right, I'll make the pre-sentence investigation report part of the record. The Commonwealth, as far as evidence, I do have, victim impact statements that I have already reviewed.
They were submitted in writing.
Is there any objection to those victim impact statements?
Your Honor, my position, I talked to the Commonwealth, is that some of them fall outside the definition under.
Okay, which ones? Are you objecting to certain ones, or are you not?
Your Honor, the specific ones are the ones that relate to Christine Banfield, so the family members of Christine.
So you object to those victim impact statements?
Yes, Your Honor.
Okay.
And Judge, what I would say to that is that certainly the statement of facts that we presented, and that is included in the pre-sentence report, includes information about also the murder of Christine Banfield. I understand that this charge itself reflects the killing and the murder of Joseph Ryan. However, I do think that the voices of Christine Banfield's family are important in this hearing as well.
I understand, but he's only been charged with the murder. I mean, she's only been charged with the murder of Joseph Ryan.
Yeah.
So the only victim impact statements the court can consider are the ones based on which the Commonwealth has charged her with. So I can only take into consideration the victim impact statements from Joseph Ryan's family.
Understood,
Okay.
Your Honor.
That's
So
the
I'll
right
do
call,
that,
Judge.
and I'll grant your motion. Okay.
I know it hurts the family's
All right,
feelings, but
do you have
that's
any
the
other
right call
evidence?
legally.
Judge, I do, in light of the court's ruling, I'm going to have 2 witnesses to call. The first of which is going to be Deirdre Fisher.
Okay, Deirdre Fisher.
She is appearing via Teams.
All right. Okay, ma'am, if you could just raise your right hand for me. Do you swear or affirm to tell the truth under penalty of law?
Yes.
Okay.
Good morning, Ms. Fisher.
Good morning.
Could you please state your name for the court?
My name is Deirdre Maureen Fisher.
And can you tell the court your relationship to Joe Ryan?
Joseph Ryan is my son.
And can you tell the court of any psychological injury that you have received resulting from this offense, or any changes to your personal welfare, lifestyle, or relationships resulting from this offense?
That's a big question.
Is this outside of the statement that I
No, ma'am.
am going to read?
You go ahead and read
Just
your
read
statement.
your statements.
Oh, so I read it now?
Yes,
Is
ma'am.
that correct?
Yes, ma'am.
Okay. All right. Thank you, Honorable Judge Penny S. Ascaretti, for giving me the opportunity to talk about the impact of the murder of my son, Joseph Nathan Ryan. My baby boy was born 2 days before Christmas, making that our special holiday. His middle name was Nathan, which means gift. Since Joe's murder, I haven't been able to take down my little Christmas tree, which sits behind the urn with his ashes. I say good morning to him each day when I turn on the tree's lights. But of course, that's not Joe sitting there. He can't say, I love you back. When Joe was taken from me cruelly and callously, murdered by Juliana and Brendan on February 24th, 2023, I lost so very much, more than I can possibly name. I lost my confidant, someone who knew me deeply, listened without judgment, offered advice with my best interests at heart. I lost my biggest ally and my cheerleader. That empathetic voice saying, Mom, you got this. Mom, you should be kinder to yourself. I lost my rock and protector. The person who flew down repeatedly to take care of me when I had cancer. I lost the comfort of knowing that my son would be there to care for me when I'm an old woman with illness or dementia, just as he cared for his grandmother and grandfather. I lost my financial sustainability due to grief's torturous effect on my health, both physically and mentally, which has affected my ability to work and function. I lost my peace and sense of well-being. I can never unhear Joe's moans and cries after he was shot, the cries of a dying man. I can never unsee the image of his lifeless, bloody hand from the trial images. I lost nearly all my friends who couldn't handle dealing with someone lost in grief or understand why my life can't just go on. I lost the chance to ever be called grandma. I will never have that. I lost the sound of Joe calling me the most beautiful word in the world, Mom. I lost my Christmas baby, Joseph Nathan, my greatest gift. The impact of Joe's loss doesn't go away. Will never go away, but only grow. So many tears, so many times reaching for the phone to call him, only to remember that he won't and can't pick up. So many times hearing the phone ring and wishing it was him, calling me out of the blue about something happening in the world or in his life. So many empty Christmases and so many birthdays without him singing to me in his awful yet beautiful voice, tone deaf. So many moments of trying to remember the exact sound of his laughter and fearing that someday I won't. So many sleepless nights. So many nightmares of his brutal murder and fear, confusion, and of the pain he must have felt. So many screams and guttural cries into my pillow, feeling the loss of my son. So many moments of reading horrible things online, lies told about who Joe wasn't. So many moments defending and explaining who my son was and why he couldn't have committed the murder of Christine Banfield. God rest her soul. So many conversations with others, draining them and me of a chance to make happier memories together. So many stomach aches. So many doctor's appointments, hospital bills, feelings of shame about my health. So many times wishing I could tell Joe about another milestone in my weight loss journey, seeking better health, knowing how encouraging and proud he would be. So many lost moments, so many moments of loss. My son's life was used and thrown away, seen as worthless and utterly disposable. Disposal by those who plotted and executed his brutal murder. Do I think or dare hope that there will be justice for Joe's death? For my loss as his mother? I don't believe that's possible. What I do hope is that, even for a moment, that the world and you, Judge, will say Joe meant more than nothing, that he was someone worthy of dignity and life, who didn't deserve to be used and thrown away, treated as utterly disposable. Thank you for listening and for weighing the trail of pain and loss Juliana left in the wake of her calculated, cold-blooded murder, with her life and future as her only concern. My son, Joseph Nathan Ryan, was not and is not disposable. Thank you for listening.
Thank you, Ms. Fisher. Please answer any questions that Mr. Campbell may have.
There will be no
Cross-examination.
questions.
No cross-examination. Okay, thank you, Ms. Fisher.
Thank you.
All right, your next witness?
Judge, the next witness that I have is going to be Ms. Sangeeta Ryan, who is present in court.
Okay, Ms. Ryan?
Only 2 witnesses allowed to speak during this victim impact statement because Juliana is not charged with Christine's death, only with Joe Ryan's. The other witnesses are for the other family.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
Move the microphone so we can hear. Oh, she's going to face
Good
the
morning.
judge.
Good morning.
Can you please state your name for the court?
Sangeeta Ryan.
And can you describe your relationship to Joe Ryan?
Is this where I read my statement? Who I met, Joey Nathan Ryan, was my nephew. And Honorable Judge Ascarati, thank you so much for the opportunity to speak today. Thank you for allowing the Ryan family to speak up for our Joey Nathan Ryan.
The mic needs to be moved.
We thank the jury for helping us achieve justice for Joe and Christine. And we thank the Fairfax County Police Department, the Commonwealth Attorney's Office, and all that helped, and we are grateful for justice. So our family has remained silent since the devastating loss out of grief, but also out of respect for the justice system. For us, Joe did not just die on February 23rd, 23. He was murdered over and over again, every time lies were spoken, every time his picture was posted alongside salacious stories told by 2 wolves in sheep's clothing who perpetrated this crime and attempted to destroy the memory of 2 remarkable people. Julia and her boss/lover intended to snuff out the life of 2 innocent victims who deserve to live full and meaningful lives of their own. Well, while we acknowledge the defendant for eventually coming forward with the truth, telling the truth doesn't absolve her of responsibility. Honesty is something we're taught at a young age. Telling the truth doesn't erase the harm. It simply allows others to move forward. It doesn't bring Joe back, and it sure doesn't bring Christine back. Hearing the truth has finally allowed us to exhale. It validated to the world what we already knew, that Joe was not the monster he was portrayed to be. Rather, Joe was an elder brother, a brand new uncle, the eldest cousin and confidant to 4. He is my beloved nephew and a son and grandson to his loving family. Pardon me 1 second. We acknowledge that Juliana was a young woman in a foreign country, in love with her employer in a situation where the power imbalance was not in her favor. But where our compassion ends is with the one other responsibility. Juliana was entrusted with and received payment for the care and protection of a small, innocent child. And Juliana, I feel, failed Valerie repeatedly. She was trusted to protect this young charge, but instead chose to cause irreparable damage. She robbed her of her mother. She stole childhood memories. She chose to partner in the brutal assassination of her mother's character, as well as her beautiful being. The defendant and her boss/boyfriend convinced Valerie that a stranger broke into her home and killed her mother, when in fact the monsters were the very people who cared for her after the loss. Julie and her boss worked to erase her mother's existence and credibility and place the blame on an innocent man. Our hearts go out to all of Christine and Valerie's family. What an absolutely incredible person she must have been. But may I tell you about Joe? Joe is loved. Joe came to live with the Ryan family. I'm sorry. I'm so sorry.
Take your time.
Joe came to live with the Ryan family just days after his birth. His birth parents, Dad Sean and Deirdre, who you met, were teenagers, so Joe lived with and was raised by his paternal grandparents, Connie and Jim, for all of his life. As a young child, Joe, who we call Joey, was fun-loving and loved from the beginning. He was inquisitive, curious, smart, charming, and so dang talkative. Joe approached strangers and passerbyers with random and nerdy questions about Transformers and movie characters and the Legend of Zelda video game characters and who would win in a battle between this person and this person, and he respectfully waited the answers, whether you knew them or not. As he grew into adulthood, Joe's hobbies included building or painting anything that used his fine motor skills. He loved martial arts. He had a great love and respect for our environment, animals, especially mistreated, neglected, and ugly dogs. And he rescued many injured and less loved dogs, bringing them across the country in his travels safely home to the home he shared with his grandmother. Joe cared for people, he cared for animals, and Joe didn't hurt people. When Joe's grandfather, Pap, required care due to a debilitating stroke, Joe left his life in Virginia and moved to Florida to serve as the full-time caregiver to his grandfather, the grandfather that supported him from infancy. When Pap developed dementia and had to move into a memory care facility, then Joe moved back to Virginia where he began to take care of his grandmother, who had begun to experience health problems of her own. Joe took over transportation for medical appointments, hospital procedures, food shopping, and the bond between Connie and her grandson was as close as that of a mother and child. Joe would never have put himself in a dangerous situation that would risk his ability to continue to take care of his beloved grandmother or his old ugly dog, Kitty. I'm sorry, she's not ugly. When Joe didn't come home, Joe's grandmother, Connie, lost the gentle man that she and Pap raised as their fourth son. Joe's sudden murder devastated his grandma, who was 81, and devastated her so much she could no longer live in the family home without Joe, and quietly and quickly sold her home to dodge memories, grief, and reporters to move closer to my husband and me. My husband is Joe's Uncle Jimmy, and I'm his Aunt Gita. In Joe's absence, my husband and I made the decision to leave our careers and to take over his grandma's support and care team. We continue to do that today, and we think about and talk about Joe every single day. Honorable Judge Asgarati, we feel Joe and Christine were targeted by the worst kind of monsters, the kind who live among the victims and wait until they're the most vulnerable. We feel as a woman, a caretaker, and as a daughter, Juliana had opportunity to stop this brutal assassination. We think she could have warned Christine. We think she could have warned Joe that morning. This could have been a very different ending where Juliana saved 2 lives. But that's not. At least she should have done the job for which she was being paid to protect a child. She did not. So many opportunities to do the right thing, and Juliana over and over chose not to. And while we acknowledge that she found the strength to tell the truth, it doesn't absolve the responsibility. So today we leave here finally standing as Joe's family. This nightmare's ending. It's our hope that Juliana doesn't walk free, but continues to reflect on how she became capable of doing this, so that when she does return to Brazil, she never victimizes another person, never betrays another child in her care, and never again places selfish desire above human life. She doesn't deserve to profit. We hope that can be enforced. The reality is, though, she will be free one day, and our hope is that she carries the weight of the lives destroyed, that Juliana chooses to live as a decent person, and that she is truly remorseful. The sentence that Juliana receives today is not the only one given. We all carry a life sentence of grief, even after hers ends. We ask for peace. We ask to be allowed to move forward. Today we move forward by returning Joe's kindness to the world. We say his name proudly. We invite the world to finally know the man we protected in silence for so long. He is loved. We miss Joe, and our family is devastated by the way he was ripped from our lives. Joe won't complete painting his unfinished Warhammer 3D figurines. He won't compete in any more live-action role-playing battles with silly, hand-created foam weapons, nor his mixed martial arts or video game battles. He'll no longer bore us with lectures about eating organic food over junk food, but it's with our hearts we thank you, Honorable Judge, and the jury that was here, members of the court, the police, the detectives, the prosecution team, the victims team, and all the witnesses who supported justice for Joe. Thank you so much for listening.
Please answer any questions that Mr. Campbell might have.
There are no questions.
All right, no questions. All right,
The-
Thank you so much.
Thank you, Ms.
The
Wright.
witnesses
Judge,
both.
I don't have any further evidence, but I do want to acknowledge to the court that the family of Christine Banfield is here today. You can see them to your honor's right.
All right, thank you,
Along
ma'am.
with Joe's family.
The witnesses
All right,
both
thank you.
reference
All right,
the trial
Commonwealth
of
Rest for
Brandon.
evidence, for the defense residents, I do have
Even
for
though
your
that
evidence
doesn't
the
apply
memorandum
to
of support of sentencing, which I have
Juliana very
reviewed. In addition, 3 letters that you have provided
Yes, Your
as
Honor.
well. I reviewed those as well.
Your Honor, I'm going to hand up a few certificates that Mr. President, they can just be made part of the record there.
Okay. Are
And
these
no
okay
further
to be,
evidence.
can be part of the file, or do you need copies? We can make copies of them if you'd like.
That'd be fine, Your Honor.
Okay,
Thank
we'll
you.
make copies. All right, let me just review them, please.
The last witness, the brightness in her voice is probably a combination of both nervousness for what she's doing and an attempt to
All right,
avoid
we'll go
from being
ahead and make
emotional.
copies of these certificates and make them part of the records as well. All right, any other evidence from the defense?
No further evidence, Your
All right, argument?
Judge, the Commonwealth in this case, as the court is aware, made a recommendation, and the Commonwealth stands by that recommendation.
All right, argument?
Let's see,
you,
stick
Your
to the
Honor.
plea deal.
Your Honor, the 2 witnesses that you heard from today made it clear that hearing the truth was valuable to them, to the Ryan family, and it was the truth that Juliana spoke at trial. And ultimately, it was her testimony that likely resulted in the conviction of Brendan Banfield. Until her cooperation, the Commonwealth had only a theory. They had circumstantial evidence, but no direct evidence. When Juliana finally came forward, she offered that direct evidence of what crimes she'd been involved in and what crimes were committed by Brendan Banfield. Your Honor, our position is that justice requires that the court follow the joint recommendation of the parties. Justice requires it because it was an arm's length agreement made by an experienced prosecution team with the approval of the head of the office, with the knowledge of all the facts and circumstances of the case, not just the facts of the case, but issues that would be presented at trial, the presentation of evidence and witnesses, sentencing guidelines, and many other factors that the parties consider beyond what the court might realize. Justice requires it because Joseph Ryan and Christine Banfield and their families deserve justice. By accepting responsibility in this case and cooperating, we avoided 2 trials. We assured the finality of the decision in this case, and we gave the jury and the Commonwealth and the court confidence that Brendan Banfield would be convicted, as he ultimately was. Justice requires following the agreement because every individual that makes...
Following the recommendation.
Recommendation, yes,
Thank
Your Honor. And I addressed that in my memo, of course.
Yes.
Every individual that makes a difficult
Following the
decision to
agreement,
cooperate
recommendation.
does so with the belief that the recommendation would be followed or at least considered by the court. The Commonwealth, the courts, and prosecutors in courts everywhere in the country rely on cooperating witnesses to do what Juliana has done in this case, which is to speak to the truth and offer direct evidence of crimes, including those cooperating witnesses that they themselves have committed serious offenses. When a prosecutor makes a promise, the court ought to give it serious weight. Your Honor, I'll say I'm disappointed but not surprised that the Commonwealth didn't advocate today for the recommendation. I have deep respect for Ms. Bristler and Ms. Sands and the prosecution team. I suspect that this is frankly because of public sentiment regarding the agreement that they made.
Recommendation.
She corrects
I'm going to
me
continue to
again.
make
I
that mistake.
understand.
Oh, wow.
Your Honor, I just want to touch on a few things that I've just reviewed.
Yes, yes.
Your Honor, the importance of the cooperation. Ms. Sands did communicate to me that she interviewed the foreman of the jury, who said 3 things to them, 3 things that Ms. Sands relayed to me, that they believed Juliana Perez Magalhães, that her testimony was integral. That was the word that Ms. Sands used. In other words, central to their decision to convict Brendan Banfield. And third, that they didn't believe Brendan Banfield. Your Honor, that is important for the court to consider because, again, up until her testimony, which was presented first in the Commonwealth series of witnesses, the Commonwealth had only a theory. The Commonwealth had circumstantial evidence, forensic evidence, electronic forensic evidence, digital forensic evidence, and others. But it was Juliana who ultimately told the story firsthand of what occurred. Because that decision was integral in the jury's decision, I think it could be said, and of course the court presided over the entire trial. You can determine her credibility yourself, but the jury certainly found it integral to their decision. And for that reason, the Commonwealth's recommendation, the joint recommendation, should be given heavy consideration by the court in this case. Your Honor, I briefly want to just touch on the delay in cooperating. It was evident to the defense that from Juliana's first date of arrest that they wanted her cooperation desperately. Her cooperation didn't come quickly. And our position is that at that time, she was still under the grip of Brendan Banfield, and the plan that he had convinced her would work. She still believed that there wouldn't be sufficient evidence for a conviction, and she was relying on Brendan's plan to get her through her arrest and prosecution. As she languished in jail, discovery dripped in. We really didn't receive significant discovery until after the preliminary hearing in this case. And even leading up to the trial date, we still hadn't received much of the digital forensic evidence that was made central to Brendan Banfield's case. Your Honor, the tipping point was perhaps the arrest of Brendan Banfield. That broke his grip on Juliana. The communications between Brendan and Juliana ceased. There were no further assurances that things would be okay for her, that they would have a life together afterwards. She was left alone, truly alone. No communications from his mother or family or other people, and no ability for her to actually contact her own family. She was left alone upon Brendan's arrest, and that was a huge factor in her coming forward. Your Honor, when she did come forward, we moved rapidly. We had a lengthy debrief followed by a plea within a day or two of that debrief. The next several months resulted in continued debriefings. We were available at every request of the Commonwealth. She continued to be candid and open with her statements, and I haven't heard any issues with her reluctance to answer questions in those debrief sessions. Your Honor, if she hadn't testified, there's a good chance that Brendan wouldn't have been convicted. First, the Commonwealth believed her. Secondly, Brendan chose to testify himself. I doubt he would have done that without her testimony. He chose to directly challenge her statement of offense, of her account of what occurred, and he was caught in his own lies. Beginning with shortly after cross-examination, the question of whether he loved her or not, and him saying, well, I didn't really love her. There were certain things that were in the way. And finally ending with his testimony about an important meeting that he was going to. Upon reviewing that testimony, his boss came forward and testified the next day that there was no meeting. Brendan's lies ultimately resulted in his conviction, but he might not have testified if Juliana hadn't testified. Your Honor, I appreciate the comments of Joseph Ryan's family, and I've read the letters that were filed by Christine's family, and there's no words I can offer to console them at this time. But it is critical that there was no trial in this case, that there is finality for the families, and that there was cooperation by Juliana that resulted in Brendan's conviction. Your Honor, the last thing I want to comment on is the agreement in this case, the recommendation.
Thank you.
I had hoped the language of the plea agreement says that the Commonwealth recommends. It doesn't say they have to get up and advocate or pound their fist and argue to what extent the cooperation was important. But the court can weigh that yourself. It was critical. Her cooperation and testimony was critical to the outcome of Brendan Banfield's case. This was an agreement for a recommendation that was made with full knowledge of what the facts were of the case and what public sentiment might be regarding the agreement for Juliana in this case. The agreement was made anyway.
Recommendation.
Thank you. The recommendation was made with the input of all the victims, of the police department, and all the important people as required by law. And there was no pushback at that time, Your Honor. I have a position in my sentencing memo whether this is an agreement or a recommendation under A1A or C. I'll maintain that argument, Your Honor. I ask that the court follow the joint recommendation of the parties and impose an active sentence of no more than time served in this case.
All right, thank you, Mr. Campbell. All right, Ms. Perez-Maglise, if you could stand up, please. If you could stand up, Ms. Perez-Maglise. Is there anything you wish to say at this time before sentence is imposed?
Yeah, I would like to read a statement. I have caused you all pain that cannot be measured and forever changed so many lives. I pray for forgiveness from the Benson family and from Joseph Ryan's family and from Valerie. I will never forgive myself for the pain caused. I hope that my cooperation in this case somehow begin to help repair the damage caused. There is nothing I could possibly do to make it up to you, to your loss. Sorry. There are so many regrets, but this is my biggest. That's a tragedy I have been carrying with me, and I will always do. It's something I have nightmares with. A tragedy I know I can never take back the devastation of what I have done. I know that my remorse cannot bring you peace. I hope you might someday understand that I truly do not believe that his plan would have actually happened. I have grown so much over the past 3 years. I look back at my younger self at 22 years old, falling head over heels for someone 15 years older. They only seen his good side and clinging to someone that showed me love. I lost myself in a relationship, leaving my morals and values behind, and putting even my loved ones through this. My time in jail has been a time of reflection for me to better myself in more ways than I realized I needed. I had to find myself again. That's when I truly found God, when I had lost the desire to live, when I wanted to die. The guilt and feelings that I didn't deserve to live and that I was a monster were overwhelming. In God, I found the forgiveness and mercy, and I am restored. Jail is not a place you can bear to let yourself drown in those feelings. I wanted to disconnect from my pain and the guilt and get into survival mode to stay mentally sane, because inevitably, with the memories come pain. Yet, I know I will live with this for the rest of my life. God and I only know the shame and guilt and sorrow I carry for all I have caused. Sorry for Joe's family and Christina's family. Sorry for Valerie, an innocent little girl who has so much love that will grow without her mother and our father. This is a heavy burden to carry, knowing I could have prevented it at all from happening. I understand that I am to blame, and I'm truly sorry for the pain it caused. I hope someday I can be forgiven, as I hope to be able to forgive myself. Thank you for the opportunity to speak.
All right, thank you, ma'am. All right. In this matter, the court does find that the manslaughter charge was the large benefit of your bargain for testifying, which was a huge bargain in a plea deal. You could have been facing life plus 3 years, and now the maximum I can sentence you to today is 10 years. That's clearly a trade for your cooperation with the Commonwealth and what the Commonwealth offered. And you accepted that along with the Commonwealth's recommendation for time served, which is not an agreement, and as you know, not binding on the court, as we discussed at length at your plea. The reduction of the charge is a mitigation. I have watched your interviews and I watched you testify, and I just cannot find any further mitigation factors for your case. You may not have come up with a plan, agreed, and an older man may have groomed you to a point, but I want to list for the record the facts that I cannot equate with accepting a time-served recommendation. These are aggravating factors either not fully captured or not reflected in the sentencing guidelines. Number one, until today, you have shown no empathy for the victim in this case. Number two, you were more involved with the plan than you testified to. First off, there were numerous postings on social media platforms and text platforms looking for a target, texting and speaking directly with Joseph Ryan, encouraging him to bring the knife, and ultimately through the phone conversation, getting his consent, knowing all along you were bringing him to his death. Lying to Christine and setting up the plan for the zoo, using her devices and hiding her phone, using a child as a pawn in your plan, waiting outside for Joseph to show up, calling Mr. Banfield to bring him to the scene, and at any point for at least the month prior or that day, you could have stopped this. The plan did not work without your full involvement. Number three, having the loaded firearm in your pocket. Number four, bringing a child into the basement knowing two people were about to be murdered, to include the child's mother. Number five, hearing Christine ask you to call 911, which you did and then immediately hung up. Number six, seeing Joseph Bryan, who was shot in the head at that time, still moving and walking up to him as he lay moaning on the floor and shooting him point blank in the heart. Number seven, watching as Mr. Banfield stabbed Christine over and over again. Number eight, waiting 15 minutes before recalling 911. Number nine, telling a fabricated story for over a year and a half, a story that depicted Joseph Ryan wrongly as a rapist and a murderer, an innocent man. And number 10, telling the child it was okay to call you mommy hours after the murder. Your actions were deliberate, self-serving, and demonstrated a profound disregard for human life. So let's get it straight. You do not deserve anything other than incarceration and a life of reflection on what you have done to the victim and this family. May it weigh heavily on your soul. So today I'm sentencing you on a manslaughter charge because that's what's before me. And the facts of this case demonstrate an intentional and calculated level of violence that is the most serious manslaughter scenario that this court has ever seen. Therefore, I do sentence you to 10 years in the penitentiary, as required by Virginia Code 19.2, 295.2. After you've completed your 10-year sentence, I will order an additional 2 years suspended, and you will be placed on probation pursuant to Virginia Code 19.2, 303. Since you have been convicted of a felony in Virginia, a sample of your DNA will also be drawn for the state police database. Are there any questions, Mr. Campbell? All right, anything further in this case? No, ma'am. Okay. All right, you're remanded to the custody of the sheriff.
Done.
I believe that completes the docket. Is that correct? I believe so. Okay. Court will be in recess. All rise.
She'll serve out the remainder of her 10 years. Obviously, anytime she has spent in custody up to this point would be counted towards that 10-year time that she has to be in custody. So that time served gets counted toward that. So she doesn't have 10 years starting from today. But when the sentence is over, then the rest will take effect. The recommendation was for time served, meaning basically let her go today, or as soon as possible, sometime tomorrow, and deport her immediately. The prosecution didn't argue for that case, and defense took issue with that. Right? This was the prosecution's deal they brought forward. They didn't argue for it, and instead just said we're sticking with what we asked for. And defense is like, they should have argued for it, but instead he had to argue for what they asked for. The judge deviated as far as she was able to deviate. And as the defense attorney put it, there was strong public sentiment against that deal. It was a bad deal for the family. We heard in the witness statements, the two witnesses which were able to discuss the impact on them. Both mentioned Brendan's trial. The first one thanking the jury. Juliana did not have a jury. She pled guilty. The second one talking about, seeing the pictures through trial and everything else. They've sort of been using Brendan's trial as seeking justice in Joe's case, because they didn't get that trial. They didn't get that moment to parade out the evidence against her. And so they sort of blended the two into one. So much so that the family of Brendan was present today to give victim impact statements in Juliana's case. But Juliana having not been charged with Christine's murder, sorry, the family of Christine, I said Brendan. But because she was not charged on the other side, she was only charged with Joe's case, then it was only appropriate for the judge to hear victim impact statements from family members on that side. But it was nice of them to mention, especially the second one, was it Sanjita Ryan, to mention Juliana failing Valerie, the daughter, her responsibility, that she was paid, the whole reason she was here, that she was paid to take care of and protect and raise and help raise. It was nice of them to say that in their statements as much as they could, obviously not being able to bring up directly Christine in the trial. But amazing statements. The judge did the only thing she could, and I think she still, wants to spit the words out of her mouth that she had to say, only sentencing 10 years. But her hands were tied. The law is what it is. And part of that is based on what she was charged with. The judge can't up the charges. The prosecutor decides what charges to bring. And they also decided what sweetheart deal to bring as well. All right. With that, let me tell you where we're at. It is lunchtime. I'm 15 minutes into a YouTube meeting that I'm supposed to be paying attention to. Oh, man, this is nuts. Let's see. Let's go. Box 4 is 4. And cut. On our deliberation timer, our verdict watch timer, we've got 4 hours and 14 minutes that the Brendan Banfield jury has been deliberating. We haven't got any indication of any more letters or emails or whatever, what have you. Colloquies, discussions. I don't know what is wrong. I don't know what is wrong in New Jersey, but it seems to be the communication between the jury and the judge is more difficult there than it should be. We saw that with a 45-minute process of the jury asking to see pictures, which any other state would have let them watch on the TV or a computer in the jury room. Instead, they're brought out to watch a couple security camera footage tapes of a car driving by, and it took 45 minutes and 3 exchanges and 3 letters in the file to figure it out. But I said I'm mixing Paul and Brandon. Sorry, Paul Caneiro, Brendan Banfield. This is why we don't mix our cases up. I'm sorry, guys. You guys know what I was saying, and I'm trying to listen to my YouTube manager and the other as well. All right, we're gonna do a quick break for lunch. It's 12:17. Here's what I'm gonna do. I'm gonna keep my ear to the ground. If anything happens in the Paul Caneiro trial, we're gonna come back live immediately. You're not gonna miss anything. But other than that, we're planning on about an hour for lunch. We'll be back at 1:15. You guys, please be good. Have a great lunch. I'll try to build a portal, and let me build the portal now. That's what I'm gonna do. Let's see. All right. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again in about an hour. You guys have a great lunch. We might have a verdict today. You might have verdict music. It is Friday. We're at the end of the work week, and it's been quite a week for sure. Thank you very much for being here. Thanks, all of you. Please grab hands with the portal buddy and jump through the lights. Let's see. Trying to get it all set up here. Visibility. Coming back at 1:15. Building the link right now. There's a lot to do, guys. Sorry, hang on. All right, portal is built. Now we're set. Now I can pay attention to my meeting, have some lunch. We'll see you on the other side. Aaron Blackmon. Well, frustrating at times after all my travel, I believe we have the best legal system. Flawed, yes. In some places, one may wait months or years for charges just to be heard in court. Those places are known as Georgia. Aaron Blackman. You guys have a great lunch. We'll see you afterwards. Bye-bye.